Hey guys, good morning. Good morning. We've got Georgia Supreme Court oral arguments today. I believe they're doing an induction ceremony first, and then it looks like the Fani Willis v. Bill Cowsert et al. Is the first thing up. Happily Angry Lawyer might be joining to co-host.
All
We'll have to
rise.
see. If
The
not, we're going
Honorable
to end up
Supreme Court of
redirecting over
Georgia
him
is
to
now in
watch Brian
session.
Steele.
Chief Justice
I
Nels
think he's the
S.V.
second
Peterson
case coming up.
presiding.
If not, we'll watch it all here. So we'll see how that goes. There is no sound right now in the court, at least that I hear.
You may be seated.
So we'll make sure we get some sound. And I have a recap if you guys are confused, like which Fani Willis case is this?
Good morning, ladies and gentlemen.
This is the case
Good morning,
over
Counsel,
the
and
Senate.
welcome
we have
to
a
the
Jim.
Supreme Court of Georgia.
We have a
Madam
Jim.
Clerk, do we have any requests for the admission of new members
I don't
to
see
the
a
bar of
Jim.
the court?
Yes, Your Honor. The following named applicants have properly certified applications.
Well, while Jim gets
and I
it together,
respectfully move for
we'll
their
also see
admission
if
to
the
bar
court
of the
turns their
Supreme Court
sound
of
on.
Georgia.
When your name is called,
Shout out to
please
everyone
step
that's
forward
joining.
and
We've
stand
got
before the
CMT
bench
in the
to take
building.
the
Thank you
oath.
for the gardening lessons.
Allison Altman,
We've got Tatum,
Lillian
Amber Dawn,
Andrews,
Tracy
James
Talks. Good to
Arnett
see you.
Jr.,
The wonderful
Zachary
Amy E.
Ayer,
Trey
Claire
Keisha,
Anderson,
good to see you.
Katie Anderson,
And Jim, you good to come up?
Chital Brombaugh, Matthew Cooper, Gabriella Corselli,
I can't hear you, just so you know.
Harrison Feinstein,
1 second.
Siri
Okay.
Faustin,
So guys, this is not,
Braxton
we
Harvey
know that
Jr.,
Fani Willis
Michael
had
Hosea,
the
Jay
disqualification
Jong,
hearing. That was
Luke
different.
Julian,
We also
Chandler
know that there
King,
was the
David
open records
Cornell,
request with Ashley
Shannon
Merchant.
Llewellyn,
That was
Shannon
different.
Llewellyn,
This is
Carter
the
Lewis,
special committee
Jalen
from the
Marchand,
Georgia Senate that was
Kimberly
looking
Marroquin,
into
Michaela Manley,
investigating the
David
conduct
McDonald
of Fani
Jr.,
Willis, largely in
Derek
relation
Law,
to the 2020
Danielle
election
Ortega,
case
Dion
and
Peoples Sr.,
how she
Julian
hired
Pierce
Nathan
IV,
Wade.
Jennifer
So a few of the
Podesta,
key questions here,
Ashanti
and it is going to be the
Robertson, Bren
admission
Routley,
ceremony,
Olivia Walter, Matthew
which I don't hear
Schlager,
still,
Karen
which is a bit odd.
Sears, Jacob Center, Joy
But hopefully
Smith,
they'll get that sorted.
Robert Warren, and Noah Wilson.
But this is all about separation of powers. How much power does the Senate
Good morning.
have to
I hope you're all well
investigate
this
somebody
morning.
in an
Please
executive
raise your
position
right
like a
hand
district
and listen
attorney?
carefully to the following
Fani
oath.
Willis has previously
You do
argued
solemnly
for an
swear or affirm
emergency
that you will
injunction
conduct yourself as an
in
attorney
front of
and
Judge
counselor of
Shakira
this
Ingram.
court, truly and
Ingram
honestly,
agreed
justly
with
and uprightly,
the Senate
and
committee,
according to law,
ruled against Fani.
and that you will support the
Fani
Constitution
then
of
tried
the
to do
state
a
of
motion for
Georgia and the
quash.
Constitution of the United States.
Judge ruled
So
against
help you
her.
God.
And
If you
then
agree to this
she
oath,
still
please
refused
respond by
to
saying, "I
turn
do."
over everything she was requested through the subpoena.
It is,
So this has
you
been
can
an
put your hands
ongoing
down.
fight. She
It
was
is our
ordered to turn some
tradition
stuff
for
over,
one
and
of
now
the
she's appealing
justices
that
to offer
decision to
words
the
of
highest
welcome
level.
to our
So that's
newly
where we are.
admitted members. And this morning,
Okay, you
that
guys
honor
can hear
falls
it?
to Justice
Sweet.
Bethel.
Thank you very much, Chief.
Oh,
I'm glad to see
all right.
that word got out that I
You
was
ready,
giving
Jim?
the opening remarks. I really do want to welcome and extend congratulations to a large
Okay,
group
There
of
we go.
I can hear
employees.
everything now.
We are thankful
can hear
That's
that
weird.
you are
Yeah, I can hear you,
practicing. We are
and
thankful that you are seeking it.
sorry guys, I don't know why I couldn't hear the admission ceremony, but now I can hear it, and I can hear Jim. So let's get this party going.
Themes of these remarks is to give thanks, to be thankful for what this day represents. Obviously, it's just a singular process, but it does create a punctuation mark or an opportunity in your life to look back and give thanks and maybe send a text or a call or an email or even a handwritten note to somebody who encouraged you along the way to say, today I was admitted to the highest court in the state of Georgia, and you were a part of that, and just say thanks. So I do want to commend that to you.
Shout
And
out to
then
them.
in terms of the message I have for you today, the Scottish philosopher Thomas Carlyle, that's the only reference to a philosopher I'll make, so you don't have to zone out quite so fast, talked about these two things he called that were the mystic faculties of humanity, memory and hope. And it was the idea that we can live outside the present through our memory and through our hope. And I'll just make the observation that in the legal world, I think there's a real connection to that the laws that we have adopted, the laws that we live under in the present, are a product of our memory, our shared common past as people. And our hopes for the future.
I love the embroidery on the
are really
chair.
captured by the process of shaping and moving the law. And I think lawyers play a
check
part
the spelling real
throughout
quick.
that process. In our
Yep,
system of
looks good.
government, those that are empowered to change the law
got a little Dom Wiss.
have the
I
legislative
can't see the
power.
John Wiz, so I'm gonna let it slide.
And so next month, before our court sits again, our friends across the street will
I think it's there.
convene for the
Maybe it's
General
not.
Assembly. And they will be trying to capture the hopes of the people of the state of Georgia in the law that is to come, the law that will be. And so my word of encouragement to you is make sure that you know your legislative delegation, that you have a relationship with them, that as someone who is trained in the legal profession, they know
This
you
guy
have an
is
interest in
ready.
their work, not just on your particular points of interest, not just on your passion projects, but that you care about the law more generally and that you do cultivate that relationship. And while you're at it, let them know that you appreciate that they will, many of them, be away from their families, from their businesses, their communities, from their churches, from wherever they come from across the state, and that you appreciate them investing in that hoped-for future that we will all hopefully share together. So congratulations and welcome, and I'll turn it over to the chief to give you your instructions.
Well, thank you, Justice Bethel, and congratulations
Look
on
at all
behalf
those
of the
nerds.
entire court on your admittance to the bar of our court.
Oh,
And
someone's looking
now you
slimy.
can follow the deputy
Oh, yeah, the
clerk
tie.
to
Green.
sign the roll of attorneys, which all of us have signed who are members of the bar, and you'll receive a certificate, which, as former Chief Justice George Carley liked to say, is suitable for framing. Congratulations and best wishes. And you can go that way.
Get the hell out. Oh, man. Let's see. Where's Lance? Okay, Lance is in the corner. I don't like it when anyone puts Daddy in the corner, but that's okay. Andrew's in the corner, too. That's very upsetting. Look at these guys last in line. Imagine. They should spice things up. There should be one person who's
We
not
got
a lawyer
just a
in there,
minute.
and the judges
Let
have to
them.
guess who it is.
Like Clue.
Why am I not a judge? I have so many ideas.
During today's argument session, the court will hear argument in 3 cases. The clocks are on the clerk's desk to the left and the right of the podium.
Nice.
Counsel will have 2 minutes of uninterrupted opening time to present key points, provided that we remember to leave you the full 2 minutes. We will do our best. And you may invite questions at any time. Any rebuttal time that you have reserved in advance by the appellants will be deducted from the total time allotted from the main argument. Any time remaining from the main argument that is not used will be added to the reserved rebuttal time. Counsel are not required to use all their time. Concise and focused arguments are often the most effective. And with that,
They're like, please.
Madam Clerk, you can call the first case, and I will just ask counsel to hold off on coming to the podium until the door has closed back there. But y'all can come on up.
And I missed one thing. There was a Senate bill passed
1236, Fani T. Willis versus Bill Cowsert et al.
in May
Roy
of
Barnes
this year
for the appellant and Josh Belinfante for the appellee.
that solidifies the legislative power to do these types of investigatory committees.
Yeah.
So,
Yeah, I read your little post on it, or your YouTube description. I read something.
yeah. Guys, there's a deep dive if you want to do. It's like probably like a 2-minute read. Read the description. It covers everything. I just couldn't pull out the videos when we watched the previous mess of this because they were in between like YSL lunch breaks and stuff. Like
For over
separate
150 years, the General Assembly has been very reluctant, particularly when it is only one house of the General Assembly, of giving to a regular or special committee of either of the House the right to exercise the power of subpoena, and for good reason. Recently, a committee of one of the houses of the Montana legislature subpoenaed the emails of the justices of the Supreme Court to determine the biases of those justices.
Depends.
the
The
primary
Supreme
colors.
Court shut that down, but it illustrates the fragile nature that exists between each of the branches of state government. In a federal example, just in the last few years, a House of Representatives committee issued subpoenas to the accountants and financial advisors of President Trump and his family, seeking to investigate his business relations while he was president. The
They know.
Supreme Court,
They know what
in the case of Mazars, which I'm sure will be discussed today, held the balance of powers prohibited largely such action. A committee may subpoena persons and documents, but it must do so consistent with the law and Constitution of Georgia. Now, we know in this state, since the time that Ellis Arnold was governor in 1943, that the General Assembly has said that it requires joint action of both the houses of the General Assembly, not just one house, both houses of the General Assembly to issue a subpoena. And in 2025, the General Assembly, exercising that power, passed a bill that allowed subpoena at the discretion of the Speaker and the President of the Senate. But it is not something that can be done just by one committee, one special committee, not even the whole Senate, and certainly not the General Assembly.
Counsel,
Yes.
can you speak to your, I think the argument you describe as mootness based
Yes.
on the different General Assemblies?
It is our contention the case is moot for two reasons. The first reason is the General Assembly that issued this subpoena is adjourned sine die. And under Mason's manual and established case law, the General Assembly cannot act after it adjourns sine die. Second reason that it is moot is that they have enacted a statute in 2025. Now, I will leave to another day whether I think that statute is appropriate. However, we, representing the district attorney, have acknowledged service on that subpoena and will appear on the 17th.
So, Counsel, a question on the sine die piece. I think, at least as I would process the information, I don't know that you need that to be the rule. The more powerful rule, to me, in your posture, would be that when the 158th General Assembly convened, the 157th dissolved.
Correct.
Because obviously, the legislature still has power after it adjourns sine die, correct?
It cannot take official action.
It can call back into a special session if a governor refuses to call a special session, yes?
3/5.
And if there's a DOT vacancy, they can elect a member of the Board of Department of Transportation.
Yes,
So
but
they still have power, yes?
I don't mean to
Yeah,
cut you
you're
off.
okay.
I don't argue with you about the adjournment and the reconvening when the new session, but that's happened in this case.
Yeah, I guess when
The 157th General Assembly is adjourned sine die, and the 158th General Assembly has met.
I guess what I'm trying to get a question is what is your perception of the importance, if you're right about the dissolution? I mean, we try to decide less, as little as possible, as opposed, why would we need to talk about the sine die proposition in a world where at a minimum, the same arguments would apply to the dissolution and reconstitution, at least from my perspective. And I'm trying to get at what I may be missing, why that's important.
No, I'll take it any way I can find it, Justice Bethel. But generally, even with, and I won't get into this, but I served in the General Assembly for 22 years, and our rule was when you adjourn sine die on the second, particularly on the second session, the second year, then you were done. Now, there is a provision that special committees can meet, but they can report, but they can't take official action. And in fact, what was the general practice and procedure was, even if they had issued a report, that they would readopt the report in the new session.
So that first subpoena that was issued
Yes.
by the committee in 24
Correct.
was a subpoena calling for testimony to that committee of that General Assembly.
Correct. and documents.
And the documents issue is not before us because
It's
that's all
not
been
before us
worked out.
because we've worked that out.
If we were to decide that that subpoena is now moot because the General Assembly and the committee of that General Assembly that it ordered testimony before no longer exists.
Correct.
We would not have to decide anything about the adjournment sine die, right?
No, you would have to decide nothing about that, and that's the cleanest way, in my view, and the correct way.
It also strikes me that there may be potentially another basis on which to conclude that this case is moot, and that is if the district attorney does in fact testify on December 17th, I presume your position would be she would be testifying under both that first and the second subpoena?
No, the subpoena has been reissued by the 25 committee, and we have acknowledged service.
So that word reissued is an important one. What I'm trying to figure out is what is the status of the first subpoena following the acknowledgement of service of the second subpoena?
I think it's dead. And the reason I think it's dead is because there has been a meeting of a new General Assembly.
In agreeing to appear under the new 2025 subpoena, has your client made any assertion about what authority she thinks she is testifying pursuant to? In other words, have you disclaimed that any authority from the 24 subpoena still exists, or have you just said we're showing up?
We're showing up. We're showing up pursuant to the subpoena that we acknowledge service on, which is the 2025.
And so is it your position because you've only acknowledged service as to that subpoena, the only authority that could attach is pursuant to that subpoena?
Correct.
But you've also acknowledged the validity, the procedural validity of that subpoena in acknowledging service, correct?
I've acknowledged exactly what acknowledged service is, that I have been served with that subpoena and that I will obey it, that I will come. Now,
And that you agree to the procedural validity of it.
I agree to
The text of the acknowledgement of service, and there's some handwritten notes in the margin. The original text was, in acknowledging service, you acknowledge the validity of the subpoena. And I see the word procedural was added, which I presume is for the purpose of preserving all of these constitutional arguments.
Correct. And what it is, the procedural, Justice LaGrua, is this, that the subpoena was issued and that in lieu of service by the sheriff or any other person over 18 years of age, that we will accept it. And so that procedure is correct.
He's going to
And
say
counsel,
she's 17.
Just to clarify, any questions not related to the procedural validity, but constitutional validity and these other arguments that you're making in this case with respect to that subpoena would be the subject of a new case or a different case, not this one.
And you may hear this again, because one of the things that Mazars, the Trump case, said and all, you can't you just can't pick somebody out and say, we're going to embarrass you, we're going to try you, we're going to harass you.
Saying that? Just all the
We'll
time.
make an appropriate objection at the time. I'm not a potted plant, and I can do that, and that will be before.
Well, and to that point, I understand that before the trial court, there had been litigated not simply the question of whether the subpoena was invalid in toto, but also whether there were particular subject matters where separation of powers or other constitutional doctrines may provide her a basis not to respond to individual questions. And my understanding is that the trial court essentially reserved those questions for assessment after questions have been asked and not answered, such that that issue is not presently before us.
It is not presently before you. It is an underlying question. But the federal cases, and there are many more federal cases because there's only been a handful of resolutions over the last 150 years, and they've been joint resolutions that granted subpoena powers. My favorite one is the convict leasing system from down in Macon. They granted them the power of subpoena. And apparently the legislators, when they went down there, got drunk. And
What?
so
The
one of
convict leasing system?
there was a complaint
Convict
made
leasing,
to the
which is worse, I think.
chairman of the committee and says, you should take some action. And he said, no, the General Assembly has adjourned, and therefore my power is gone. Cited in our papers. Your Honor, I'd like to reserve a little time for my rebuttal.
Mr. Belinfante.
That was a heck of an example.
He's not a potted plant.
Mr. Chief Justice, Madam Presiding Justice, may it please the court. The case is not moot. The fact that the General Assembly adjourned both as a just matter of the second legislative session and that the 158th General Assembly is now in session or soon to be does not render the subpoena void. This is not a traditional mootness case. The attack is that the subpoena is void, and there is simply zero constitutional text to support that argument, and there is no reason this court should adopt it now. Nor does the fact that the witness has agreed to testify on December 17 change the calculus today. We agree that if the witness comes and testifies and actually answers questions, it may. And we are under a professional obligation to notify this court that it has been mooted pursuant to Title V, and we will.
Boot it and boot it.
But that's not the case today. Borrowing from the presentation, we remember that we had dates before and it did not work out. We hope that it does. So with that in mind, I'll turn first to that question of just general mootness and whether the agreement itself provides a basis to not decide the case. The answer is no. While there is no specific authority on legislative subpoenas to testify before a legislative body, this matter was before the Superior Court and therefore governed at least in part by the Civil Practice Act. But 91145 does not help. That's a subpoena for trial or deposition. And 91130 doesn't help. That's a notice of deposition. So looking at this court's precedent, Rogers versus State Medical Board from 1980 is a good example. Physician was investigated by the board. He subpoenaed documents of the board. In the interim, before he got the documents, the medical board dismissed the case. There was then no need to enforce the subpoena because the physician got the outcome he was looking for. That may be the case on December. I'm sorry, yes, Your Honor.
Let me ask you a question. The previous dates that were set, there was no agreement to testify, correct?
There was going to be an acknowledgement of service on those dates, we believe, yes.
But-
And there were unfortunate circumstances with trial that prevented that.
So it didn't occur. So
That's correct.
aren't we in a different posture now since she has agreed to testify?
We are. And it very well may be that on December 18, the appellant files a motion to dismiss as moot. We don't oppose it. And under City of Atlanta, case decision from 1914 or 1944, if we don't oppose it, it's accepted as true. But
there's a second subpoena that has been issued, service of which has been acknowledged. What is the status of the first subpoena following the acknowledgement of service of the second subpoena? Has that superseded the first subpoena?
it does not. And there is no language in the second subpoena that says that it, what was the word, reissued, that it reissues. It is a separate subpoena.
So recognizing that that is a different position from your friends across the way, in a world in which your position is correct, such that there's simultaneously two valid subpoenas, I assume you would agree that if she actually does testify on December 17th, that is testimony, perhaps not fully responsive to, but testimony pursuant to both subpoenas. You would not take the position that it somehow is only pursuant to one subpoena, right?
If this case is still pending before the court, I mean, we would take the position it is pursuant to the second subpoena,
But then-
which would then moot the first.
That's
Well,
not the
but,
question.
I mean, okay,
Because she has
today,
testified.
before the testimony on the 17th that we presume is going to happen, what can actually be done with respect to the first subpoena to the first special committee?
A couple things, Your Honor. And one
Because
is,
we agree that that special committee is, I mean, the people may be the same, but that has ended, right?
yes and no. And this is a piece that I think is important and distinguishes this case, certainly from the Nebraska case and some of the federal ones. The fact that Senator Cowsert filed a counterclaim in his official capacity as a state senator to enforce the subpoena, and that provision was granted. There is a separate statutory.
Does an individual member of the legislature have standing to assert the interest of the legislature?
He could do so in his official capacity as chairman and in his official capacity as senator.
Was there any-
I've seen no authority.
Was there anything in the Senate resolution creating the committee that authorized the chairman of the committee to litigate on behalf of the committee?
It says that the committee would be authorized to enforce a subpoena, and the Senate committee's rules authorize the chairman to act.
So, unlike most other government offices, that is to say, there's an office of the district attorney, and whoever encompasses it, the office is sort of operates in continuity. You would agree, and the Constitution clearly says that when the General Assembly convenes, it is a new General Assembly. It is not a continuous process. Correct? I mean, that is the rule.
The word different appears in the constitutional text.
The word different is there, but I don't think.
What does that mean?
It would be we know it means different things, for example, on a budget. A budget that is passed or is inchoate from a prior General Assembly doesn't then carry over the way a bill does between session 1 and session 2.
Well, that's not entirely true, because the state's fiscal year splits the calendar year, and so the 159th General Assembly, whenever, God hope we have one, right? It will have a budget that it is bound by, that was passed by the 158th.
It is bound by, but has the authority to amend in the amended budget.
Which is no different than the 158th can amend its own budget.
It could, but
So that wouldn't be, what I'm saying is, it wouldn't be a power, that wouldn't be a distinction.
okay, well, forget the budget then. Let's just look at a statute. Bill fails perhaps on sine die, and on the last day in March, hopefully, of this coming year. It is not then brought back up anew in whichever chamber it rested in. It has to start.
It has to start over because it's a different General Assembly.
It's a different General Assembly.
That kind of difference seems to me like there's no other place in the Constitution that I'm aware of that provides that, say, an executive branch agency or a court becomes different simply because the people constituting the entity change over. So, for instance, the Commissioner of Defects, there may be pending litigation against the Commissioner of Defects. Commissioner of Defects resigns, new replacement is put in, operation of law substitutes that new commissioner into the litigation for the previous one, because, so long as they were named in their official capacity, because defects isn't different, it's the same defects.
Oh, defects.
Why would the substitution by operation of law argument that you're making, why does that necessarily carry over despite that word different?
Looking at the language of two statutes, 91125D and 4512, and admittedly, 45.
So before you go into what the statutes say, can a statute answer that constitutional question? I mean, if the issue is the Constitution says they're different, can a statute resolve that?
I think it can, and it speaks to what different means. And I think
But surely different doesn't mean same.
it does not mean same. I would not make that argument. And we see in other provisions of the
I understand
state
why people hate
constitution
lawyers.
where different is flushed out, whether it is because the statute is there, or whether it is in terms of an operation of law, or whether, for example, there's an exception for impeachments, that once they adjourn, that's where you address what happens after sine die. And it says the Senate can continue its impeachment
It
trial.
has to,
even if
right?
they adjourn.
It's
Yes.
not allowed to.
Yes.
But isn't it different if the constitutional language enables statutes to follow to give meaning versus just stating something is different?
It would, but here you run into another provision though. Because the power of the General Assembly is plenary, the default should be that the General Assembly can act unless expressly prohibited.
So sure, when we're talking about the General Assembly, I think part of the challenge here is, to the extent we're here over the first subpoena was not issued by the General Assembly. It was issued by a Senate committee. I don't think anybody disputes that the General Assembly's plenary power includes the General Assembly the power to subpoena, so long as it's exercised by both houses, in the same way that the other powers of the General Assembly generally have to be exercised by both houses in tandem. And if you look to Senate Resolution 465, that outlined specific powers that were the basis for the committee, the first couple of powers that it itemizes were powers that I am confident you would agree can be exercised only in tandem with the House. Those were the power of making laws and the power of appropriation.
Correct.
I think we would be in a much more challenging constitutional space had the General Assembly not acted in 2025, both the House and the Senate, to confer this power of subpoena on committees that now has been exercised in this most recent subpoena that service has been acknowledged. So you would agree that we don't actually have to answer the question of the extent to which one chamber can do that without that having been authorized, because that's not the world we live in anymore.
I think for the subpoena that is before the court would need to answer it. And potentially, I'm sorry, Justice Beck,
please.
potentially going forward, just because Senate Bill 255 passed, it is not the only vehicle by which the Senate or the House or its committees could subpoena. And subparagraph E or subsection E of the code makes that very clear.
But it's the only one pursuant to which they have, right?
It is not, I would say that the others are available. I think that, when we get into 45-117, where the power was exercised jointly, that makes sense because that legislation passed in 1943 and has not been changed since. And there was not the provision against the General Assembly limiting.
But this most recent subpoena, the acknowledgement of service that was entered into, in the last week.
Yes.
That was issued pursuant to the new statutory authority, correct?
The new statutory authority and the new resolution,
Right.
Which continues the prior committee.
Well, it doesn't expressly continue it. It says it's a successor, right?
I think that might be the phrase, but it's certainly I think it's spoken of as it redoes, but it's the fair point. But again,
So I want to rewind to the mootness argument a bit, because that's the piece that I'm wondering about. The first subpoena was a subpoena from the special committee of the 157th General Assembly.
correct.
Now we're in the 158th. We have a new special committee, or call it a successor of the 158th. That first subpoena, there's no committee that still exists for the district attorney to appear before, right? If it was a subpoena from that committee that no longer exists, from a General Assembly that no longer exists.
I think that it could because of reading the Constitution in conjunction with the two statutes that I talked about, that you submit or you just substitute the public officers and the counterclaim that was there.
That's true for litigation. Like, assume you're right that for litigation purposes, the parties have been sort of substituted for their successors. Their successors were substituted. That doesn't necessarily change the subpoena itself, right? If the subpoena is a subpoena from a committee that no longer exists, then that subpoena is no longer of any effect, right?
I would disagree. I do think the subpoena, I do think the subpoena is still of effect. And to your point,
Okay, if a subpoena was issued by an agency.
Like, where do you
of the
show up?
state,
Where do you
And
go?
before the subpoena was satisfied, the General Assembly, bicameral presentation, effective on signature, passed a law abolishing that agency and not accounting for any outstanding legal liabilities or responsibilities. The governor signs it. How would you satisfy that subpoena, or would you be under any obligation to satisfy it?
Yep.
I think it's difficult because I've seen enough of those where they typically
They
continue
assign it,
over,
yeah,
but presuming they don't
because
do
they
that
have
at
to
all.
say, that's right,
Right.
they haven't done that.
You run into, I think, administrative subpoenas at that point would be different, and there's different analyses that go into what an administrative subpoena is and does.
So what's What power does the 157th General Assembly have today?
A power to pass a bill? None. A power to effect appropriations? None. A power to see that his will was enforced and not simply delayed through litigation. And this, remember, this was a trial court that moved quickly.
If a member of the 157th General Assembly's Senate sat on this committee that issued the subpoena, and somebody said, I'm going to come testify and satisfy that, and they showed, and so they're no longer a member of the Senate,
Yeah, where do
and
you
they
show
showed
up?
up for the committee hearing, what power would they have in the committee hearings room?
To ask questions.
Yeah, that senator would not have the authority, but I
So
think
why
that's
isn't the committee different?
because I think the key here is the counterclaim, where you don't have to answer that specific question, because the counterclaim to enforce, which was part of the
But
final
it's to
order.
enforce, is it to enforce a subpoena? You do have to answer the question, because it's to enforce a subpoena that may have stopped having any force of law in January of 2025, the minute a new General Assembly was convened.
Because the subpoena isn't simply an abstract subpoena. It was a subpoena to testify to the special committee of the 157th General Assembly. That committee no longer exists, correct?
That committee as in, well, the 157th General Assembly does not exist.
I think Bonnie wanted one.
So a
But
committee of the
I would argue the
157th.
committee has been.
I understand you argue
Right.
that the committee of the 158th is its successor, and so it sort of continues to,
I mean, saying that its successor is as a descriptive term, probably true, right? I mean, it is the colloquially successor entity. Whether that means the General Assembly is a different General Assembly, though, is not, I don't think is answered
My second favorite
by
here.
the colloquial description of that committee being the successor committee.
And again, I mean, certainly, this is why it's an issue of first impression, and the ability of the court to decide that, I think, will be important. Again, maybe it won't have to, we'll know in a couple
although
of
we
weeks.
do have pretty strong prudential rules around not deciding constitutional questions of first impression if it's not necessary.
Correct, which is why I think the statutory basis to operate, whether it's 9/11/25 or 45-1-2, allows the court to avoid the constitutional question. Or the court could decide, and I think very reasonably under the authority we have, whether it's the anti-stalking provision discussed in Little or the election code in the Gwinnett Place case, that this would not be mooted because it would be susceptible to repetition, and it's
So
not
it's certainly
moot.
capable of repetition, but I don't see how it would be evading review. I mean, the problem in this case was the subpoena was issued late in the year, the second year of the biennium. If you issue a subpoena in February of the first year of a biennium, that is ample time for the courts to decide all of the enforcement questions, right?
Conceivably, unknown. The committee met in
I have
February.
great faith in the capacity of
The
the courts
committee
of this
met in
state.
February, March, and May, heard from the defendant's counsel in the case, heard from Fulton County on the budgetary issues, and then heard from district attorneys after session. And with that knowledge, then wanted to hear from the district attorney. But imagine this, and it's not hard to really do this. Let's say we're in the last 2 or 3 weeks of session and a major issue pops up, whether it's COVID, whether it's AI.
Well, that might in fact be different, but it doesn't seem like that's the factual scenario that's happened here.
Even if it is different, right? I mean, there's going to be another General Assembly coming. I mean, this is how the system of government works, is that we share power. And so in 2 weeks' time, a new General Assembly will convene. They can issue whatever subpoenas need to. If you have somebody that's openly flaunting the General Assembly's authority, whatever the authority is, you can ask somebody in the House to file an article of impeachment. And there are other tools available to move the process along.
If it's a public official, that might be available, but otherwise, if there is that late breaking provision, and then you go to trial court and you deal with the suppress issue or the motion to quash, like we did here on a preliminary basis, then on a fully briefed basis, then on a fully briefed basis with objections noted and decided, then.
Although part of that is just the fact that it is not the traditional function of the General Assembly to engage in that kind of investigative efforts. I mean, that is not, I mean, a number of us have been around in this world for a while. That is not traditionally how the General Assembly operates.
I'm not sure that weighs against it. And in addition to that.
It certainly weighs against whether it's likely to evade review, it seems to me.
It's possible, but I think there's a lot of differences in the way that, for example, political parties work or witnesses are doing more now than they were before. And to their credit, the appellant, had a great discussion of how the General Assembly operated before the Constitution was changed and said a statute cannot limit its authority. But it
Counsel, I
did
have a
happen
prac-
and can happen.
Before you finish, I have a
Yes, Your Honor.
practical question. If the 17th comes and the witness does not appear, I assume you will go back to Superior Court to enforce that subpoena as well?
I think we would have that option and start the whole process over again, and that's one reason why this court should decide the issue now.
I have one more question before you step down that I did ask your friend across the way. The question of scope is not presently before us, right? My understanding is the trial court expressly reserved the question of what would happen if she appears, but specific questions are not answered. And you would agree that's not before us?
It is not before you, but it is also not before the trial court because there has been a final order entered. So if there
would need to be a new enforcement action pursued in the event that happened.
That's correct.
Okay, thank you.
Thank you.
This just seems like it's making things inefficient.
Very briefly, if I may, my distinguished brother here wants you to issue an advisory opinion. That one house or a committee or a special committee can, regardless of the 25 statute, can issue subpoenas. And that simply is not before you. I mean, that issue has been mooted. And this argument, well, there are some ways that you can go past the different, in the words of the Constitution, General Assembly and enforce something is simply not supported by law, case law, or the Constitution. The General Assembly dies and has no further effect when a new General Assembly comes in. I would suggest when it adjourns sine die, even though it may be recalled. And this business, well, an impeachment trial. Oh, one body can do an impeachment. Yes, but that is specifically set out in the Constitution. Same thing with the budget. The budget must be introduced in the House.
Seems like they're
All
setting it up
tax
like when
measures
school's
must
about
be
to
in-
end and you do nothing
Not
for the last
because
2
they
weeks.
want it that way. It is because the Constitution requires it.
Well, and in the context of the budget, the act of passing the budget is the appropriation. There's not really a continuing
No.
appropriating power. It's just the appropriation occurred, and then it can be amended later on.
Right. And this idea that both committees, I think it was Justice Penson or Justice LaGrua, both committees are successor and are finished and all that stuff. These members are not the same. There is at least one member who retired in between the two General Assemblies, is not a member of it. So,
Counsel, I think I heard your friend across the way essentially say that if the district attorney shows up on the 17th and testifies, from their perspective, that functionally satisfies the issue that's before us, whether we all agree about that. So would you agree that, notwithstanding the other mootness arguments, that would moot the issue that we're in front of us?
yes,
So if she just shows up and testifies, then there's really nothing left for us to do.
absolutely.
On
Absolutely.
Oh,
this appeal.
Yes, on this.
On this
I understand.
subpoena. Now, like I say, I mean, you got a bunch of folks on this committee that's running for statewide office, and they're putting out fundraising information. We're going after Fani Willis. Those are issues that we will take up at a later case when they've been formed. Thank you.
Thank you very much. Counsel for both sides, well argued. We will get you a resolution within the time required by the Constitution, and we look forward to a status update following December 17th.
They want a status update.
He's being sassy.
Look at them.
He's being so sassy, and they all know it. You have 2 terms of court to answer the question, and there's a subpoena. She has to appear in, what, a week?
Yep.
So they're going to wait and see.
Yep.
The
Well,
games that are being played.
I think we heard a lot of questions, but to me, it just seems like they're trying to figure out if they even need to address whether subpoena is defunct once a General Assembly ends and another one starts. And they don't really need to answer that question because it would become moot if if the second subpoena is still valid.
Yeah, for sure.
So it seems like they don't really want to measure. And I see why, because if you try to say, hey, you can't just let a subpoena float, you might be setting up a precedent where one General Assembly can just indefinitely have subpoenas sitting out there with no end in sight.
Yeah,
but on the other hand, if you say the opposite, then you're setting up inefficiency for the final months of, or letting the recipient of a subpoena sit there and say, all right, I can just hold out on this, and as long as I keep delaying it, it'll go away. So look at his face over here. What's his name? Pinson?
Yeah, Andrew Pinson.
So our next,
the redheads are number 1 and number 2, clearly.
Oh yeah, she's making a face. She's got it too. I didn't look at her. I was gonna say, do you have any more commentary on this case? They really didn't. They just focused on whether or not a subpoena can survive a turnover in assembly. The first one.
Yeah,
They
I think
didn't even weigh any issues on the second.
Yeah, I think the angle that they kind of were getting at towards the end is like, how do you even comply with it? Like, setting aside whether it's valid or invalid, like, where do you show up to answer questions? There's no like 150
The John Travolta
to show up in front of.
The John Travolta meme.
Exactly. Yeah, I think that's what Pinson's question. Somebody asked a question about like meeting the requirements.
Yeah, it was Pinson that started with, well, what power does the 157th General Assembly have right now? Can they make someone answer questions? Can they? And they're like, no.
Yeah.
So that was Pinson.
His face is so funny. You're right. That was a good catch.
So we'll have to see what the next case is, and then maybe pause if you want to give a background on when we see which one's called next.
Yeah,
Do you
I
think
assume
you
it's
have
going to be
background?
the arbitration one, but I don't really know
Okay.
it that well. But yeah, let's see.
Okay.
Stand out about
Oh no, sorry.
Yeah.
Well, we won't pause anymore.
the case below and the Burke-Moore Law Group case. Second, the question invokes offensive equitable estoppel specifically. It is framed in terms of a signatory bringing affirmative claims against a non-signatory and then using those affirmative claims to drag the non-signatory into arbitration. And there's a bright line rule that's in play here, which is that you can't use equitable estoppel offensively. Burke-Moore recognized and applied this rule, as did the 11th Circuit in World Rentals, the Second Circuit in Thompson CSF, and the District Court in the Citigroup versus Berggren case. The Court of Appeals in this case did not acknowledge that it was applying equitable estoppel offensively. It did not even acknowledge below the issue of consent. So moving quickly to question 2, did the arbitrator exceed his powers? Quote the 11th Circuit again, the Clay case, 2004. If a dispute is non-arbitrable, then an arbitrator necessarily exceeds his powers in adjudicating it. And so the arbitrator clearly exceeded his powers here, and the Court of Appeals decision should be reversed.
Is there any example of a Georgia case where the Georgia courts have allowed the use of equitable estoppel offensively to compel a non-signatory to arbitrate?
No.
Has that ever happened?
The only time that's ever happened is in the case below. As a matter
Is the case below in direct conflict with the prior decision of the Court of Appeals on that issue, the Burke-Moore case?
It's in direct conflict with Burke-Moore, Your Honor. As a matter of fact, as far as I know, The decision below is the only decision in the United States of America that endorses the offensive use
I agree.
of collateral estoppel. And
Equitable stuff.
I think it's completely right.
I keep falling into that. Thanks for correcting me. Equitable estoppel. I don't know why I have collateral stuck in my mind. But focusing on the Burke-Moore case, Your Honor, the facts of that case match this case. The Burke-Moore law firm was not a signatory. The signatory party, Drew Eckel and Farnham, asserted concerted misconduct claims against Burke-Moore and two signatories.
So what if the facts here, what if the facts here were such that piercing the corporate veil separating the signatory Jackson parties from the non-signatory would be appropriate? Would your answer be different?
Well,
I mean, it may not be equitable estoppel at that point. It may be a different doctrine, but.
Well, thank you for that question. Piercing the corporate veil is one of the traditional common law doctrines that can be used to bind a non-signatory to a contract. And I think this court understands and appreciates the severe showing
guy's faces.
that is required to get to a finding of piercing the corporate veil.
Well, and there's something intuitively appealing about that. I mean, I think I recall seeing arguments here of the nature that these entities were so intertwined that they were essentially acting in concert. But there was no finding of the veil being pierced here, correct?
Well, it's even stronger than that, Your Honor. There was really not an argument that the veil should be pierced.
But am I right that there were some of the arguments of the predicate to that, saying that the entities were intertwined and acting in concert and things like that, and then the next step just wasn't taken?
The argument that was advanced in support of equitable estoppel is that equitable estoppel should be used because Rickshaw is wholly owned and controlled by a
Unity of
signatory.
interests, this kind of thing?
No, there's no argument about that.
It's simply wholly owned argument?
The argument, as part and parcel of the equitable estoppel argument, they said, use equitable estoppel because Rickshaw is wholly owned and controlled by a signatory.
Does that matter? Does that matter, absent a finding that we should pierce, the trial court should pierce the corporate veil? Does the fact that they're wholly owned matter at all?
It's completely irrelevant. And the fact that the arbitrator mentioned the fact and the fact that the court below mentioned that fact, I think really shows that they used really a hybrid approach that's been rejected, for example, in the Second Circuit. And what the hybrid approach is, which has been rejected uniformly, is that you have these different contract and agency principles, these very limited principles under the common law to bind a non-signatory to a written contract. And you have different ones. You have piercing the corporate veil, which is its own doctrine. And then you have equitable estoppel, which is its own doctrine. Some district courts have used a little bit of piercing. They talk about the close relationship of the parties, and then they use a little bit of equitable estoppel. They talk about, the allegations and concerted misconduct. And courts like the Second Circuit and Thompson CSF say, when you use a hybrid approach, you dilute the safeguards that a non-signatory is entitled to.
Right, because all of those theories essentially are trying to say that what would otherwise be unfair, binding a non-signatory, is in fact fair because of certain principles that show that they did participate in the process, right? That's the theory that animates it?
Well, I think the theory that animates those rejection of the hybrid.
Well, I'm talking about the theories that could bind a non-signatory.
Right. I mean, they're really traditional, contractual, common law theories that are very difficult to make work.
Sure, but follow my thread just a little bit farther, which is those theories work when applied correctly because they're essentially saying that the non-signatory was in fact part of the process, right? Is that a correct shorthand way of
Yes.
explaining?
Say yes.
That the non-signatory,
The man is
based
eating
on
his
that
glasses.
doctrine, is bound by that written contract in all respects.
But what's the why?
Well,
Normally, non-signatories can't be bound. So there's a principle that runs through all of those theories about why a non-signatory could be bound.
Well, I think the why depends on the doctrine you're using. If it's piercing the corporate veil, it's because somebody's using the corporate form to perpetrate a fraud. That's the why. And equitable estoppel is a doctrine of equity. Fairness is a part of every equitable doctrine.
And your brothers across the way are going to get up next and tell us that those same animating principles do apply here.
Okay.
So I'm trying to unravel what that why is to better understand why you think it doesn't apply.
Well, there was no unfairness here, okay? Because the non-signatory
His face.
did not do what the equitable estoppel doctrine considers unfair.
So were there findings of fact at all to get to any of the theories?
No,
I hate this argument.
there were no findings
You
of
should have
fact.
found
They will argue that the Superior Court made a finding of fact on motions for judgment on the pleadings and for summary judgment. They argue that the Superior Court made a finding of fact.
Okay, I'll wait to ask them that question.
The second question before this court really focuses on, did the arbitrator exceed his power in joining Rickshaw? And the arbitrator didn't make any findings of fact in that preliminary jurisdictional determination.
Is that second question just binary depending on what we do with the first question? I mean, if we say, if we answer the first question that equitable estoppel can't be used to bind a non-signatory to an arbitration agreement, offensively anyway, does that compel a yes answer to the second question?
Pretty much.
And is there any other to yes for that second question if we say that actually equitable estoppel could be used this way? If we say equitable estoppel could be used this way, thoroughly follow that the arbitrator didn't exceed his authority?
I think if you say that equitable estoppel could be used defensively, I think it will be shown that the arbitrator didn't exceed his powers.
So in other words, the arbitrator could have erred or abused his discretion, but would have had authority to reach that conclusion in the first place.
Well, I guess the thing I would say is that the arbitrator did not really apply the equitable estoppel doctrine. Keep in mind that the equitable estoppel doctrine, and this is in the record, was specifically argued to the arbitrator. And we said in that briefing, we said to the arbitrator, look, Rickshaw is not a signatory. Equitable estoppel, let me borrow the words of Burke Moore, the rationale
right
for
term.
applying
The little water.
equitable estoppel does not exist. If you join Rickshaw, we argued to the arbitrator, you're going to create a vacature problem. Don't do it. And so we argued equitable estoppel in multiple briefs before the arbitrator, and the arbitrator, I don't believe, applied equitable estoppel. The trial court didn't say that the arbitrator applied equitable estoppel. The trial court conducted its own independent equitable estoppel analysis. It wasn't until the case got to the Court of Appeals that for the first time somebody said, well, he didn't.
So what is your understanding for the legal basis that the arbitrator had for adding Rickshaw?
He used a hybrid approach. He said, Rickshaw is wholly owned and controlled by a signatory. He mixed in parts of the concerted action line of
But those were
equitable
all, those
estoppel
sounded
cases.
in equity. This hybrid approach you're talking about, I understand the point you're making, that it didn't fall cleanly into one paradigm, but it sounded in equity, right? The whole point there that the arbitrator was making is that the arbitrator thought it was only fair to join.
Well,
You might have disagreed with that, but that's the thought behind it, right?
I think what animated the arbitrator were an issue of judicial efficiency. I mean, if you read the arbitrator's ruling, it's really, I just think that all of these claims should be adjudicated in this arbitration proceeding because it's efficient to do so.
Well, so, I mean, if that's true and the arbitrator didn't rule on an equitable estoppel basis, do you get relief from a decision from us if it were to say equitable estoppel is not a basis, or do you have further work to do in the Court of Appeals or somewhere else to overturn the arbitrator's decision?
Well, we would have further work to do because there's the issue of whether vacature is all or nothing. There's clear Georgia law and federal arbitration law that shows that, especially with an indivisible award like this.
So Alex Spiro vibes over
An
here.
award can't be vacated in part, and we would have to raise that with the Court of Appeals.
Definitely.
Thank you, counsel. Mr. Testani.
Okay, so basically, really quick, there was a business, it broke up, and one of the partners just tried to force the other partner into arbitration, but the business that was forced into arbitration wasn't party to an arbitration agreement, but then the arbitrator
May it
forced it
please
into
the
arbitration
court.
anyway.
The court has asked
Beautiful.
whether the arbitrator
Beautiful.
exceeded his powers
Drop some
by
mics in the
joining
chat.
Rickshaw to the arbitration,
He did.
citing
Definitely
Section
did. This
10
isn't a
of
court
the
case.
FAA in its question. That
This is no
section
remote close
concerns the
case.
bases on which an arbitration award can be vacated. And it's important to note that this case involves an award against five signatory parties
matter.
plus Rickshaw.
Yeah,
Those
that's the
parties
issue.
have no
Plus Rickshaw.
basis, those
That's
five
the whole
parties
point.
have no basis whatsoever to obtain vacature of the award as to them. As noted by the Superior Court, those five parties missed the 3-month deadline to move to vacate the award as required by the FAA. That's an absolute bar to their ability to request that this court vacate the award as to them, and yet that's part of their appeal here. As also discussed in our brief, the
That might be
non-Rickshaw
true,
parties
but that's beside
contractually
the issue.
agreed that the arbitrator's decision would be final, binding, and non-appealable, and such an appeal waiver is enforceable
Doesn't
and should
matter.
be given effect in this case. The court and the arbitrator also found that the award against those five parties was joint and several. So each one of them is liable
Joint
to
and
the full
severable
amount
or
of this
several?
award. So this talk about an
Several.
indivisible award is totally irrelevant in this case. It is
That's
not
right.
an indivisible award. It's a joint and several award.
Did you
Each
say
one of those
indivisible?
parties is bound, and 5 out of the 6 have no basis to even be in this court. Now, as to your question, the first question, the doctrine of equitable estoppel is available to bind a non-signatory to arbitration when the non-signatory relies on a contract when it works to its benefit and advantage, but then
Whoop.
repudiates the contract when it works to its disadvantage. That's the principle behind the
phone in the
doctrine
court.
of equitable estoppel. And so when Mr. Bogan talks about Rickshaw being dragged into this arbitration, hardly. They intervene in everything but name in their actions in this case, and those are
Yeah, see,
they
the
rely
but
on
name
the
part kind of matters, though.
What's that?
How did Rickshaw rely on the contract?
Rickshaw-
As opposed to simply conspiring with the signatories?
Yeah, and this gets into the
Upset.
facts, and Justice Land, in the arbitrator's decision at pages 16 and 17, he lays out how Rickshaw relied upon the contract, the operating agreements in this case. And what Rickshaw did with its owner, Mr. Jackson, they understood in the operating agreement there was a 90-day deadline, strict 90-day deadline to close the buy-sell transaction. On the eve of that 90th day, Rickshaw and Mr. Jackson presented so-called legal opinions into the arbitration, saying that certain option agreements that accounted for millions of dollars of real estate assets that were the subject of this buy-sell were unenforceable. Therefore, they would not be conveyed as part of the buy-sell. That cratered the transaction, as the arbitrator found, and
But
he
counsel,
referred to
isn't
it.
that just interfering with the operating agreement? I mean, I mean, you can make the same argument that the attorneys who helped them do that were also somehow interfering with the agreement. Would they also be subject to arbitration as a non-signatory?
No, the point is Rickshaw benefited from that provision
Well,
of
the
the
attorneys
contract.
benefited by their attorney's fees
Well-
that representing Rickshaw, and so would Rickshaw's attorneys be also subject to the arbitration agreement?
It's a direct benefit to Rickshaw, and we'll talk about this, in terms of
Well,
direct
they may have
benefits. to stop.
benefited from it, but how did they rely upon the terms of the contract? I don't understand that.
Okay, the operating agreement in section 9.6 provided for a 90-day deadline. This was a major issue in the case to close the transaction. They knew our client had to get financing, and they
So
knew
they
that
knew
if,
what was in the contract. I understand that.
so
And they may have engaged in conduct as a result of what was in the contract, but how are they relying on the provisions of it to assert their position?
they relied on the deadline, and on the 90th day, not coincidentally, they submitted the legal
Yeah, because of the
opinion saying
contract
that
doesn't mean they're like
To
relying on
upset
it.
the
That's what
deal,
it
to
says.
interfere with the deal, to upset it.
to retain
Not-
the
not-
This is
assets
borderline
to
frivolous.
themselves, which is the direct $1 million plus benefit to themselves, to not have to transfer assets over to the other side. That's one instance of direct benefit. The second instance of
But if
direct
direct benefit is the standard, sorry, I know there are a lot of people, if direct benefit is the standard, what deal would not be subject to estoppel? I mean, all the time in complex business structures, one related entity may benefit from the actions of another. That would be, the exception would swallow the rule.
Well, that's why we cited the cases from the Second Circuit and the Seventh Circuit that talk about direct benefits estoppel, which is a species of equitable estoppel.
Were there findings as to that species of estoppel here?
There are findings embedded in the arbitrator's award indicating what happened here.
Sure, but is it correct that you're gleaning the theory from the disparate findings as opposed to the arbitrator saying, this theory was brought to me, I find that the veil was pierced, or I find that this, is there any analysis of that type?
The facts are the analysis, and what we need to keep in
The
mind.
facts
is
are
that
the analysis. What?
The kind of standards.
I almost
that
said a
court
word
would
I
be
can't
in
say.
Deciding the issues.
Oh my
Sure, but
God.
courts, I mean, as we saw here, then take what the arbitrator has found and then they review it and put labels on it as well, and we have an obligation to investigate that.
I can't express
And
how
that's
bad
why I
this
think
case
the
is for
arbitrator's
him.
decision at pages 16 and 17
law's
outlines
extremely
exactly
clear
what
on this
benefits
point.
Rickshaw obtained. The other thing that's very important here, and frankly extraordinary,
You have
is
to be-
that
you have to be a
Rickshaw
part of your
asked for an
arbitration
award of
agreement. Very
attorney's
black and
fees
white.
under the very provision of the agreement that contains the arbitration clause.
But the issue is like it's
I mean, if that
retroactive, right?
isn't
Like
a
they
direct
already
benefit,
forced
if
it,
that's not relying upon
and now they're
the
trying to
terms of
say
agreement
it's
to your benefit,
invalid
I don't know what would be.
retroactively
in this
because it
context,
shouldn't have been
seems to me
enforced,
that the
right?
way you're using direct
Yeah,
benefit
I
is
think-
essentially sort of the inverse of tortious interference with contract, right?
Nerd.
I mean, the way you framed the direct benefit that Rickshaw experienced was them
Thank you, Derek.
acting in a way that could constitute tortious interference with contract.
It could have, but it also resulted in a direct benefit to them because they did not want to turn over the real estate assets to my client. And by doing what they did and relying upon the strict, look, this was a big debate in our case about the 90 days. We had a whole set of motion practice about
So
this.
why isn't that? I mean, that is an independent tort, right? It could be, as you have alleged it.
It could have been, but we presented our lump of claims to the arbitrator. And the arbitrator decided, that's the nature of the arbitration. We made a claim for aiding and
it's not.
abetting, breach of fiduciary duty. Okay, that was part of the thing. The arbitrator decided that there was a breach of the operating agreement and found the parties liable for breach of contract. Okay, that's what he did. That,
Okay.
in this proceeding or any court proceeding, the courts don't second guess the arbitrator's
Aren't those just theories of liability as opposed to theories of making a non-signatory arbitrate? The breach of fiduciary duty, the interference, the tortious conduct, the wrongful conduct, the conspiring, aren't those all just theories of liability to hold the non-signatory liable as opposed to theories that justify joining them to an arbitration they didn't agree to?
They're both. I mean, the facts here supported the theory of liability and the facts.
Even though
supported
they're
their
not
joint.
relying on provisions of the contract to assert their claims or defenses at all.
Well, they did rely on the provision of the contract to ask for an award of attorney's fees. That's the basis on which they asked for
That
it.
was after the fact, after they got brought into the arbitration, correct?
Yes,
So
except,
once they're subject to the arbitration, they say, well, if I'm subject to the arbitration, I want my attorney's fees. Are you contending that works an estoppel against them?
yes, and here's why, Justice Land.
So they can't assert a claim for attorney's fees?
Not under the
After the fact?
contract.
Okay.
I mean, you can't have it both ways. You either are bound by the contract or you're not bound by the contract. Now, if they wanted to bring a 13611 or something, that's
At
different.
the time they asserted their claim for attorney's fees, they said that they were not subject to the contract.
Well, that was, let's see, 6 months after they fully participated, made various arguments, presented.
Well, they fully
things-
participated because they were told they had to, right?
Well, by an arbitrator.
Yes.
They could have gone to court. They could have done any number of things to stop. And that's the difference between Burke Law Group in this case,
Yeah,
by the way.
that was my next question, is how do you reconcile what happened here in the panel versus
Very
what happened
easily. I
in
mean,
Burke?
look, the thing is, what's before you is not an interlocutory decision by the arbitrator to join Rickshaw in January of 2020. What's before you is an award that was issued. And when you cite to the FAA, there is no vacatur of an interlocutory decision. Where we are is there's an award
Can
because
you
they.
can you reduce that down for me? Sort of what's the summary reason for why Burkemore's reasoning does not apply here? Or why there's not a irreconcilable conflict
Yeah,
between
because
the
it's
two
an incorrect statement of the law.
Insofar as what?
Insofar as that the only time, when Judge Barnes says the only time you can join a non-signatory is when they're the plaintiff. Why is that? That isn't the law, and we know from direct benefits estoppel that non-signatories are joined as defendants. We have the Vital case and we have the Everett case that we've cited. So it is not categorically the case.
So you would acknowledge that that statement of the law, we would need to affirmatively rule that that is wrong in order
It
to.
is a common way, it is probably the most common way in which non-signatories are joined. It is probably the most common
No,
way.
it's not.
But it is not the only way.
In addition to having to disclaim what Burkemore said to get to the answer that you're seeking, wouldn't we also have to extend the law in Georgia? Meaning, I understood your argument to be, well, we haven't seen a case just like this where equitable estoppel has been applied, but the animating principles behind it, the rationale applies, which is really asking us to extend the law one click further.
No, because the Burke.
Because it has not happened before.
Well,
Wouldn't we
this
have-
factual setting has not happened, but the principles articulated in Burke Moore Law Group are correct principles. The panel in Burke Moore got it right when it talked about the fact that, and I had it here somewhere, but when it talked about the fact that the principle behind equitable estoppel is you can't embrace a contract and then seek to repudiate it. That principle is the same principle we have in this case. So equitable estoppel doctrine is based on that principle. That is correct. So that is not a change in the law. It's just as the application to the facts here. Yeah, we will have now an instance in Georgia. We will have an instance in Georgia where a non-signatory who did rely on the benefits of a contract and then seeks to repudiate it is bound because it came up in a procedural context
But
that
it
is
didn't
different.
seek it I mean, I
Yeah,
think
it was
Justice Land had a
bound
question.
to it and then
Asking
it
us to
actually
extend the
didn't.
law based upon findings that did not really address any of the theories directly that you say gives cause for us to extend the law. It just seems like to me we have half of what we would need to do what you're asking us to do.
Well, the standard of review for the factual findings of the arbitrator upon which this theory is based is clearly erroneous. Okay, so,
It is.
you know,
It is.
arbitration is different. And the idea that there's some risk here that strangers
It
or
is
third
different.
parties off the street are going
And
to
that's
be
more
dragged
protected.
into arbitrations and they didn't sign an agreement is frankly
Yes.
preposterous. We have two cases unfortunately decided in the same week. Their case, by the way, the Burke Law Group, was decided after our case. When the arbitrator made his decision, when the Superior Court made its decision, when our Court of Appeals made its decision, Burke Law Group rule had not been even articulated. And it isn't a correct articulation of the rule. And you can look at the Second Circuit cases, you can look at the Seventh Circuit cases, you can look in the Sixth Circuit, Eighth Circuit, Ninth Circuit. They all recognize direct benefits estoppel as a species of equitable estoppel. And in some
The Ninth
instances,
Circuit.
non-signatory
Really?
defendants are joined in those cases. And frankly, why would it matter? If that
Well,
party is behaving.
somebody very close
as
to
this
me
party,
argued that Ninth
Rickshaw,
Circuit case.
in relying on the
opposite's
terms
right
of the
next to me.
contract, both before they
And
were
I know for a
joined
fact that he's lying about
and
that.
after they were joined, then it fits right down the middle of that principle. And the other thing I would mention about Berg Law Group is, look, that court found correctly,
Steele's
I
up next.
think, that the
After
breakaway
rebuttal.
law firm from Drew Eckel, that firm and the lawyers who were not former Drew Eckel partners
I
were
don't get
not
how
relying
asking
on
for
the terms of
attorney's
the Drew
fees
Eckel
after a
partnership agreement
decision
in any way.
is a waiver
Totally
beforehand. I'm
contrary
still
to
stuck
the
on
facts
that.
in this case where Rick Shaw
makes no
and Rick
sense.
Jackson were
I can't
relying on
understand how
the
the Court
terms
of
of the
Appeals came
agreement
out
to
this
get a
way.
benefit, not
Crazy.
only before they were joined, but importantly also when Rick Shaw sought an award of attorney's fees.
So recognizing that, the questions before us really are just straightforward, maybe not straightforward, but they're legal questions. Can I ask just a practical question that may or may not be relevant? What, if the award
I'm dying to hear
against
this.
these 5 or 6 parties is joint and several, why does it matter? Don't you eventually get paid the full amount of the award from the other parties regardless of whether Rick Shaw is on the hook?
Yes. And that's why I'm mystified by being here, because we've gone through almost 3 years of litigation to get an award. 5 of these parties have no basis whatsoever to challenge it, none. I mean, not only because of the standards that apply to merits-based determinations in arbitration, but because they missed the deadline to move to vacate. I mean, and they agreed they wouldn't appeal, and yet here we are. So to answer your question, even if Rick Shaw, if you decided, Berkmore Law Group is the rule in Georgia and only a non-signatory plaintiff for whatever reason can be joined to an arbitration, if that's the rule that this court wants to articulate, in contrast to what the 2nd, 7th, 9th, and 6th, and 8th circuits have done, fine.
He's just wrong about
But
that.
it has no bearing, and this is my first point, in terms of the arbitrator exceeding his powers as to those 5 parties. Absolutely not. And that's the question, and that's procedurally where we are. We have an award. That's the subject matter of this appeal. It's not an interlocutory decision about joinder or non-joinder, which was the issue in Berg Law Group. So you're at the end of an arbitration. That was up to them.
Why do you think that makes an actual difference here? Because it seems like the question is still the same, which is, can this non-signatory be joined? One is at an interlocutory posture, one is post hoc. Why does it matter that one was temporary?
Because they have made the argument that what happened after the joinder doesn't matter. And I would say to you, it does matter. Their behavior in the arbitration, the arguments that they made, their reliance upon the provision asking for attorney's fees
Sure, but if you get
matters.
compelled to show up in court,
Yeah, then you
and
think you're already
show up
there.
because you're compelled, you're going to put up a fight, right?
Yeah, except they
It's like
weren't compelled.
precipitory.
The arbitrator said, I'm going to reject your motion to not be in this arbitration. A court can compel.
Okay, but it is
It's not a waiver then.
substantively similar. If you're going to be bound, you're going to then assert if you're told you're going to be bound, notwithstanding your objections, you're going to then assert whatever you can assert to protect your interests.
Yes,
not a
except
waiver.
you have a decision
And
to
the
make.
the question in the first place was, could you be bound? And that's the same question in Berk Law Group.
It happens all the time when parties will be joined to an arbitration
No, it
over
doesn't.
their objection.
No,
they
it
fully
doesn't.
participate.
It
in
never happens.
They ask for some affirmative relief, as this party did, and the court will say, you know what? You participated, you waived that objection. And that's part of our argument too, is that
But he was
whatever
compelled.
happens here with
They
Rickshaw,
were
number
compelled.
one, it doesn't matter as to the other 5. Number 2, they had choices, like Berkmore Law Group had a choice. They went to court and said, please don't, stay this arbitration, right? We don't belong in it. And that's the decision that got made. Here, they said, okay, fine, we're going to stay in this, and we're going to make our arguments. And one of the arguments they made is award us affirmative relief under the terms of the contract that contains the arbitration
Well,
clause. I don't think you can have it both
let
ways.
me make sure I understand that. What you just said would require us to
gonna be
hold,
good.
and I think you indicated we've held this in the past, that full participation by a non-signatory in an arbitration over their objection results in a waiver of their objection?
It depends on the facts. These facts support that, yes.
Whisper, whisper.
And
Why?
Why?
you can't have it both ways.
Well, they're objecting.
The facts are the
And
analysis.
We're not trying to have it
drug
both ways. We're
into
trying to
it
have it
over
one
their
way.
objection. How does there
Exactly.
then participation and it result in a waiver?
You can't have your cake and eat it too.
But they weren't
Yeah,
having
but
their cake. Somebody put them in this over
I
their
don't want
objection.
cake.
Well, number one, that's not true.
they intervened into this case. That party could have stood on the sidelines. Instead, they decided, hey, let's generate some evidence in this case.
They intervened in the arbitration?
They intervened, small I intervened. They put themselves into it.
Into
by
the
developing-
into the arbitration?
What?
Into the arbitration?
Yes, into the arbitration by developing evidence to stop the transaction in order to benefit by keeping real estate assets to themselves.
That was
They didn't have
before
to do that.
was that before the arbitration was ever filed? You're talking about their conduct that gave rise to your client's claims, correct?
It was after the arbitration was filed, but before they were joined to it. That's when it happened.
Okay.
It happened
But
in
you would
September
agree they
30th.
never consented to be part of the arbitration?
Well, at some
You're
point.
not
Apart from
consenting
waiver,
that?
apart from a
Saying
waiver
indirectly
theory,
They consented.
they did not consent.
They didn't say, I consent, but what they did is they said, I'm going
Done.
to come into this arbitration and develop
I'll go back to
evidence,
bed.
use it, because I know that if I do that, I will benefit myself by being able to retain these real estate assets to myself rather than having to
Somebody
turn them
tried to
over in a
stab me,
buy-sell.
and then I
So-
fought back. I
It's
didn't
their
consent
conduct,
to
yeah.
being stabbed.
And so those are the reasons why the courts have developed
But
equitable
how would your
estoppel.
conduct in the process of an arbitration bind you? I mean, it would sort of be an unusual rule that said, you know, hey, if you think you're not bound by the arbitration, don't do anything, potentially lose everything. And then if you're right, you're out. But if you're wrong, you have lost everything that you could have gotten in the arbitration process. In other words, it seems odd to me that asserting interest in the arbitration process that you have said, hey, I don't think I should be here, would be a basis for binding you to it.
Well, again, keep in mind, Rickshaw's behavior occurred before they were joined.
Understand?
Right, and so, but that's the nature of the direct benefits estoppel vein of equitable estoppel, is that you are taking advantage of a contract in some manner. And by doing that, you can be hauled into an arbitration. That's the rule. So, thank you very much.
No. Okay, let me
Can I
explain
bring
how
that 5
arbitration
minutes
works. Oh, wait, no, there's going to be a rebuttal.
Yeah, let's do a recap app because I can't pause,
If this court wants to
unfortunately.
increase the volume and increase the complexity of litigation about arbitration, then it should accept the plaintiff's invitation to adopt a flexible case-by-case standard. Just if you endorse a flexible hook and give an arbitrator an opportunity to exert power over a non-signatory, then
Did he just try to
the
duck?
parties can make deep arguments before a trial court later about vacature and confirmation issues. To follow the Burke-Moore decision is to bring certainty in an area over non-signatories where it really needs to be certain. Now, let me address the direct benefits estoppel.
Before you go to that, what is your response to his point about the appeal waivers of the signatories that you were representing?
The appeal waiver issue was brought by the plaintiffs in the form of a motion to dismiss the appeal before the Georgia Court of Appeals. The Georgia Court of Appeals denied that motion. They did not seek review of that before this court. And when you look at the cases, the majority rule is basically that that language does not prevent a later motion to vacate an award under the Federal Arbitration Act.
What do we do if we rule in your favor for the non-signatory? What do we do with the judgment against the signatories? Anything?
Well, that issue is not before this court, okay? So
We do have to consider it.
I'm not sure I agree with that, Your Honor.
Well, let's pretend for a minute we do.
Okay. If this court
So unprofessional.
were
He
to
should make this face.
decide what I'll call the all or nothing, we would ask for an opportunity to brief that because we really didn't brief that issue. It was briefed in the Court of Appeals and the
What
Court of Appeals.
conceivable change could happen as to the signatory members by a decision that Rickshaw wasn't properly in the arbitration?
Because then you would show that the arbitrator exceeded his authority.
He's very
Only as to
emotive.
that question.
The arbitrator, that therefore the award is subject to vacature, and that because it's an individual.
I mean,
No, I'm sorry, I'm talking over.
No, go ahead.
And because it's an indivisible arbitration award, or call it a joint and several arbitration award, it has to be vacated in
So
its
unprofessional.
entirety.
Why, if everyone's jointly and severally liable?
Because that's what the Georgia law says, that we cite in a footnote in our briefs. An arbitration award cannot be vacated in part, because when you vacate it in part, you're disturbing the merits.
Well, but it's not vacating the substantive judgment in part. It would be cutting off one party.
I disagree with that, because when the arbitrator brought in a non-contracting party and mixed contractual liability
There's an
together
extra
with the
issue.
conduct of Rickshaw, he created a
Actually, kind of fits
problem
with
with
the
the
yellow tie guy.
merits of that.
Kind of
I
messed
think
up.
breach of
Jackson's
contract
the only
law.
managing
What
owner
specific
for
problem?
Rickshaw.
The problem
Because
is
it's like a
is
real
that
estate
you-
investment
you-
LLC.
you-
Like they just have a
he-
property holding
Rickshaw
under
wasn't
an
even
LLC.
sued for breach of contract. When he imposed breach of contract liability and increased the amount of damages for
Oh,
breach
that's
of
not your point.
contract based on
That's
the
the point.
Rickshaw real estate, you can't draw a line and excise out.
None of those signatory parties appealed here, though, did they? Or moved to vacate?
The signatory parties joined in Rickshaw's vacature, and they opposed the motion to confirm. The signatory parties did really everything they could to oppose
That's
confirmation
not
of
what I
that
heard
award.
from your counsel across the way.
That's not part of this appeal, though, is it?
It's not part of this appeal. This appeal is just question one and
So
question
should we
two.
just leave that issue alone and let you file whatever you're going to file in the courts below?
Yes.
Well, I recognize in response to Justice Pinson's question that there's more work to do if you rule in our favor. And that is to return to the Court of Appeals and address that all or nothing issue that we argued
Can't
to
stand
the
this
Court
guy.
of Appeals.
Not the guy talking, the other guy.
The first options case, the United States Supreme Court, you don't have to open a second litigation front to preserve a jurisdictional objection. Thank you.
Thank you very much. Thank you, counsel, for both sides. Very well argued. We'll get you a decision within the time required by law.
Time for Steele versus a million people.
Madam Clerk, will you call the third?
I want to see a couple pathological liars on the other side.
Malcom versus the state. Brian Steele for the appellant and Kevin Armstrong for the
I was
applicant.
also just
Oh, it's
looking
gonna be Armstrong? It's
Nothing.
gonna be Kevin Armstrong, people.
I was just looking at the case announcements for January 20th, and Steele has one in the January 20th, the next Supreme Court.
Busy
Yeah,
guy. Busy guy.
And then Noah Pines has one too.
Oh, I like Noah.
You know that case where it was the spousal drunk? How can I say this without
That
getting
doesn't
censored?
narrow it down.
Yeah. There was marital relations
you're ready, Mr.
when
Steele.
the couple was both drunk, and it was whether that's a crime.
Oh,
Andrew Fleischman was talking about it on Twitter like a week ago.
May it please
Because of
this
consent
honorable
issues?
court. Happy
He's gonna say
holidays.
Rock's in
I'm
prison.
Brian
happy
Steele,
holidays.
and I
He
have the honor of
introduces himself.
representing appellant. This is
Isn't
an
that lavender
indictment.
tie?
The grand jury of Fulton County returned on or about the 22nd day of November 2016, 2 counts of participation in criminal street gang activity, 1 count of
Because of
malice
course.
murder, 3 counts of felony murder, 3 counts of aggravated assault, criminal damage to property, 1 count, robbery, 1 count, possession of firearm during the commission of various offenses, 2 counts. And
2016
Always a
Fulton was
possession.
7th of 2018, appellant was convicted of 1 count of the criminal street gang activity, 2 counts of felony murder, 2
Yeah, he
counts
was
of
acquitted
aggravated
of double
assault,
counts.
the criminal damage to property, and acquitted of all other offenses. He's sentenced after merger and concurrent time. Appellant is serving life in prison. The facts are just ridiculous and horrible. It's 4 people meet in streets of Fulton County. 2 of them get into a fist fight, kicking fight. 2 guns were dropped. One
Foot
by
fight?
each participant. Appellant picked up both those guns and left with both those guns.
Thank you, Sheriff Chuck.
The deceased and the witness who testified at trial for the state then shot, a vehicle belonging to the person in the fight who was with appellant, and then, according to the verdict, in retribution, appellant's vehicle, he shared it with his mother, or it's his mother's vehicle, pulls up next to the deceased car, and the witness who testified for the state puts many bullets into that car, killing the deceased who's driving, and the passenger was shot as well. He was injured. He testified. Appellant was tried. The co-indictee died before trial on unrelated matters. Appellant has raised 3 enumerations of error. I would like to discuss, I'll discuss any the court directs, but I'd like to discuss the third one. I think that it's actually fascinating on how this honorable court sees jurors during voir dire who do not answer a question. And I think we need more guidance in the courts below.
Oh, wait, the
I'd
third
like
one
to
was the
talk
juror
about
question.
if that's
I forgot about
okay.
that.
What happens is there's a juror number 7, and some of these are not in the
I thought he was gonna
briefs of
focus
the
on the
parties,
second
and I
argument.
apologize, but the transfer pages I'm referring to is volume 3, transfer pages 26 through 41. They're general questions to the panel, then same volume, transcript 3, it's 100 to 106.
Did I tell you I talked to
That's
I talked to the
individual voir dire
defendant?
for juror number 7.
I talked to Coy the other day.
And then there's strikes for
Which
cause that are relevant. It's
Yeah,
in
this
transcript
to the
page
client.
124 and 184. And then it's record, you could look at the record for the strikes
Calm
too.
down,
So
Aaron.
record 221 through 226. And then the jury selection is volume 3, transcript page 327. That does include juror 7.
Counsel, those citations are helpful, and as you're explaining this to us, can you explain what about this juror claim is, in your view, different than the numerous other types of juror claims we see where a juror is rehabilitated?
Okay. So this juror is specifically asked this question. I'm quoting from the transcript. And this is at volume
juror,
3, page 39 through 40.
Was a victim in a case that was being
Juror is
tried
told,
in the courtroom at the
these
same
are
time
general
as the
questions,
trial
by
in
the
this
way.
case.
So the panel, the veneer panel. The juror is told that
And were they a witness to that
if they
case?
believe that a
They
question
wanted to go to
applies to
Washington.
them, but they don't answer it, please let the parties know later. So I just want to set that up. And then this is the question that follows. Anyone here knows anyone who works for a district attorney's office in, say, an assistant district attorney capacity, or, and I'm stressing this, a victim witness advocate?
That's a pretty big stretch. I mean, that was not asked, right?
That was asked.
It was asked? They said
Cool.
victim witness?
Yeah.
Oh, okay.
No, this is, I apologize. Yes,
That's good.
this is a quote. This is a volume 3, page 40.
She's like, excuse
I
me?
apologize. I knew they asked about the DA's office, but I thought they did not specifically ask about.
Don't you ever apologize. I did not put in the brief. It's my fault. So it's a transcript lines 5 through 9, though, on page 40. And this is the quote, though. May I continue? District attorney capacity or a victim witness advocate or investigator. These are some of the roles. And then it says, I'm skipping a couple of things, but it says, et cetera. And there's no reply by juror number 7. I think that's critical. And that really, if the court thinks that's important, what happens after that, is juror
I
number
know
7
James,
is
or
walked
Matthew.
individually. I gave you the transcript pages, volume 3, page 100 to 106. And
Counsel, let me ask you, when the court, once the court finds out about this and then makes the inquiry of the juror and asks the question, basically, can you be fair and impartial? Why isn't that enough to cure her reluctance, or, I don't know, maybe she didn't hear, I don't know, but her unwillingness to raise her hand when that question was asked? Why isn't that a cure for that?
I don't think it comes
There a
first
verbal
for
yes
3
or no?
reasons.
Okay.
First of all, the judge asked, when I say the judge, this is a great judge. He's retired now, but it's the Honorable Judge Newkirk in Fulton County Superior Court. And he specifically asked, and this is cited in the briefs, by the way. This is page 856 through 859. And the trial court specifically asks the question, which is what you asked. hold on, I apologize.
Are you looking at the part that says, does it have any impact on you?
Say again? No, I'm asking specifically where the juror was asked the following. The juror comes in the courtroom and is asked specifically this. And this is on the bottom of 858, starting in line 22. This is juror number 7. No one else is in the courtroom. When I say no one else, the courtroom's open, but no other juror. And this is during trial. All right, I forgot to ask you a couple of more questions. During voir dire, I don't think that you raised your card that you knew somebody or had some contact with the Fulton County DA's office. Do you remember that? And this is the answer to the juror. This is one of my answers. I remember a question related to something like that being asked, but I didn't feel like it applied to me directly because I was never robbed. I left the bag unintended and I came back to get it and it wasn't there. And the judge says, right. And she said, the juror said, but after I left, I did tell your assistant, I can't remember her name, but it did because it came to my mind. That does not answer the question at all. And the second answer I have is that in this court's case.
Why doesn't that answer the question? I mean, it seems like from the passage you read, and I remember that from the briefs too, she's indicating that there was some confusion, there's sort of a mea culpa there, this came to my mind, I felt like I needed to disclose. What more would need to have been said or known to be able to honor what she later said, which is, I can be fair and impartial?
Because she seemed to suggest that she didn't identify herself as being like the victim because she wasn't actually robbed.
The question, yes, that's the question she answered, but the question asked is, why didn't you raise your hand that you know someone in the DA's office? She didn't answer the question, do you know anybody in the DA's office, including a victim witness person? I just can't.
So the question is, of course, do you know anyone or did you have any contact with, right? Because, I mean, as challenging as sometimes be in today's society, I mean, I interact with people that I don't know. And so I think possibly the more troubling piece is, did you have any contact with the office? Because it may be true that she had an encounter with their office and still didn't know anyone and couldn't call anybody by name, didn't have a ongoing relationship. And so what I'm really curious about is, on this record, I can't tell. In other words, she was there, she was being questioned. Did anybody ask the judge, can I get a little more information on the nature of her interaction with the victim witness?
Was there ability to do more voir dire after that realization?
Very fine district attorney who tried the case. She's now a judge in Douglas County. This is at transfer page 837.
Yeah,
she announces this.
I can't think of her name, but she's a judge now. And Ash Josh, who was the defense attorney, who's
I asked the question if anybody had a case in Fulton County during voir dire, and I believe Mr. Trial Lawyer for Appellant asked the question if anyone knew anyone in the DA's office. She didn't raise her card to either of those questions, did not disclose that, and here we go. Though she is a victim in the case, she does have a case in Fulton County, nor did she disclose that she's been in pretty regular contact with the victim's witness advocates.
But was she asked, was that pretty regular contact quantified? Was she asked, how many times have you been to the victim witness office? How many times have you had phone call with? So what contact there might have been?
She wasn't asked, but I'm assuming the law is followed, and you have, not you, but there are statutes that say that victims have to be told about every sentence that's going to be court date, every bond hearing, every.
Well, they're told that,
victim's right.
Mr. Steele. That's what the law says, but you and I both know that they aren't always contacted. And she specifically said, when asked about her contact with the DA's office, I remember a question related to something like that being asked, but I didn't feel like, to Justice Colvin's point, it applied to me because I was never robbed. The bag was unattended.
That has nothing to do with anything.
They went on for further questions, and the court asked, does that have any impact on you? She was the one that disclosed. If she was trying to hide something hide the ball. Why would
But
she
when
have
did she
told the
disclose
judge's
it?
assistant that afternoon that she had remembered
They didn't get to
something that might
voir
be
dire on that,
relevant?
though.
She didn't say it that afternoon.
I'm shocked that the Fulton
Justice
County
LaGrua,
prosecutor is
question I
citing
read
the Fulton County
earlier
prosecutor.
that I quoted is, you can't make a mistake.
Well, the judge only asked that question because the prosecutor had come to the judge and said, hey, juror number 7 did not answer that question, and she's a victim in one of our other cases, right?
Right.
So this wasn't spontaneous self-disclosure by the juror.
So I think it's very clear, but there's more to it. And what I was saying about the question, I was talking about the question I read earlier during voir dire. The juror never answered that question. Even when the judge asked, why don't you raise your paddle or your
But
card?
counsel, I mean, the question that was read out during voir dire was, do you know anyone who works in the district attorney's office or is a victim witness advocate or investigator? I mean, you and we all know what a victim witness advocate is, but is that clear to just someone kind of off the
It's kind of in
street?
the
Like
name.
who is that? Like, I don't, and she said she didn't feel like she was a victim, so
But
maybe it sounded like her answer was she didn't think that applied to her because
why not
she didn't
excuse the
know
juror
anyone
later,
like
even when
that.
they find out during
Honor.
trial?
And it's a transcript again, 837. The prosecutor announced that she has been pretty regular contact with our victim
So
witness, if I can, throughout the course of her own case.
Let me ask this question. Let's say she had answered it when that question was asked. Yes, I do know somebody in that office. Can she not be
Strike.
rehabilitated after that?
She would
You don't have a
struck,
chance to.
I believe.
Is there a categorical rule saying that upon that disclosure, she would have been stricken?
Those are nice hearings.
Categorical rules. So you're
Is it an automatic strike?
That would have been a
I would hope so,
preemptory
but no,
challenge.
I don't believe it's automatic strike, but that's a pretty big appearance of impropriety. to
Well, but
let-
is your argument that she was telling an untruth and that's the problem, or that the disclosure, it's like the fact of
Both.
her knowing someone at the DA's office having contact is the problem?
Both.
The problem is, I believe, on this record, I'm not trying to criticize the person.
Sure.
But on this record, this court needs to look at, is this acceptable? Is this acceptable in the state of Georgia? When a person is a victim,
Kind of reminds me of the
current
Darren Mills
victim of
case.
a crime, that
Also
she's in
2016 case.
constant or regular contact with victim witness throughout the entirety of that case. That case
Was
is
that the
coming
star
up.
witness that ended up getting
She
the
does not
talking
disclose
to?
that.
I'm thinking
She
of
does
something
not
else.
say, I'm a victim.
I think.
Then it comes up through the honorable district attorney to say, we have a problem here.
Yeah, it was just one.
And that
juror.
district attorney says exactly what I read. And on multiple occasions, the juror never told us her reactions here, so we couldn't do strikes. And then when asked specifically, why didn't you raise your card? She gives some convoluted at best answer about, I didn't think I'm a victim, yet she wants to go to the sentencing.
Yep, she did.
So she's involved. She's not ignoring this case.
Dishonesty.
Because she's the one who brought up to the judge's assistant, but there's no evidence that she ever said that she was a victim, because the judge says you were involved in that case.
That shows
And the
conscious
judge didn't let her
downplaying
go.
rather
And
than
it's
just
Judge
not
Newkirk.
getting the
Some of you may know,
question.
some of you don't, but it doesn't matter what judge it is. A victim has a right to be present at the sentencing of someone else if they want to be there. She's in the same courthouse, and Judge Newkirk specifically, it's in the same transfer pages, for the first time says, you are a victim in this case. And she says, right. So to me, with all of that, I think that there's an inference that you can take, and I'll give you the cases, that there was a knowing desire not to reveal this. And the cases
Yep.
are,
I agree.
The 11th Circuit is, U.S. Supreme Court is McDonough, MC, Capaldillo, N-O-U-G-H, Power Equipment, Inc. versus Greenwood, Greenwood, 464 U.S. 548, 1984. And then it is cited favorably, United States versus Perkins, P-E-R-K-I-N-S, which is 784 F2D 1519. It's in Division B, as in Barry, 11th Circuit, 1984. And the
Not
11th
C as in
Circuit
Colette.
talks about what you're saying. Talks about, it's Justice Blackmun's concurring opinion. The 11th Circuit quotes it. I also agree that in most cases, the honesty or dishonesty of a juror's response is the best initial indicator of whether the juror was in fact impartial. And that resonates with me, because here you have appellant or anybody serving time in prison finds out after voir dire, and the judge does nothing about it, the trial judge, that one of the people judging him is in constant contact or regular contact.
Counsel, let me ask you this. In the order denying the motion for new trial, the trial court said, I find no misconduct on the part of the juror, which if we construe that judgment in favor of that finding, it seems like the judge agreed or bought into the explanation of the juror number 7, that she didn't mean to not raise her hand, and then she thought of it. When she thought of it, she did bring it forward. I mean, how can we, I mean, is that an abuse of discretion, that finding? I mean, how can we
Failing to
overturn
excuse
that?
Yes. So
requested.
Well,
Not
you
his
taught us
side.
abuse of discretion is an erroneous factual assertion, erroneous understanding of the law. The judge never got the answers. Just saying, can you be fair and impartial? And the answer is yes. This court is
Well,
already
but the
rejected.
judge also was able to observe her demeanor and the circumstances attendant to everything that happened. And though there may not have been a comprehensive credibility finding, there is a credibility aspect to finding no misconduct or bad faith or something like that.
But at some point, it is just an abuse of discretion. You know, I've never won a robe. This is too much. How did this get through the court? And at some point, there is a rule and there's a line, and that line does not keep shifting. And for the juror to not answer the direct question, on voir dire, not answer the direct question of the judge, not state that she is a victim in a case, and that has to come out through the prosecutor, and then not removed. Imagine if I was on trial, I gave I had the honor of representing the person.
I think
and
the abuse of
juror
discretion is the
was
judge
a
not
client
granting
of our law
excusal
firm.
when requested.
Doesn't say that. I mean, I would tell everybody, but doesn't say that. Now they're on the jury, and we're in the middle of trial, and it comes out that she's my client, and it's the same thing. She's a victim, working with the victim witness advocates, which this court, under the law from the legislature, that's an attorney work product. Those relations, they're privileged unless they're breached.
Yep.
Unless it could be
Good argument.
taken away. And that's your jury? I would hope that that juror gets removed. And that's what happened here. And this court has said in Beam, B-E-A-M versus State.
Oh, God, not Adrian Bean.
With an M as in Mario.
And show
Okay,
respect
okay.
for the criminal justice system. Allowing a juror in this position who doesn't reveal she's a victim on a current case in constant regular contact with the DA's office, and none of that comes out, to me, is the abuse of discretion. That is really how I feel, and I know my time is up. I want to thank this honorable court always for everything you do.
There were some
Thank you,
other
Mr.
issues,
Steele.
sufficiency
Mr.
of the
Armstrong?
evidence, but this is what needed the hashing out of arguments, was this specific juror voir dire, lack of voir dire, judge not excusing the juror argument. Because additionally, the trial counsel asked to excuse that juror mid-trial
Chief
when they
Justice
learned the
Peterson,
information,
Your
and
Honors,
judge said
may it
no.
please the court, Kevin Armstrong for the state. One of the first things that Mr. Steele said was that
I'm glad he could make it back from
guidance
Wakanda.
on how to deal with these issues, and so I wanted to cite some cases that were not specifically cited by the parties in the briefs. The first one is Green versus State. It is 295 Georgia 108, and the other one is Terrell versus State, 313 Georgia 120. 120. In Green, this court said that, quote, an incorrect response given by a potential juror on voir dire does not necessarily call for a new trial. And then it explained, quote, as the determinative question,
Well, sure.
is whether there exists bias on the part of the juror which results in prejudice to the defendant, end quote. And in Terrell, this court said, the law presumes that potential jurors are impartial, and the burden of proving partiality is on the party seeking to have the juror disqualified. I would point, so this court has already provided us with that guidance. And the Green case goes on to talk about if the superior court finds the juror to have been intentionally untruthful, they can presume bias in that response. But if the juror was simply mistaken and was making an honest mistake, then that is something for which the court can conclude that there was no bias on the part of the juror. And so in this particular case, after the court's second colloquy with the juror, neither party said anything about the court's colloquy with the juror and said that it was insufficient or anything else. The juror provided an explanation that they did not believe that the question applied to them. There's no question that this question was asked. Does she know anybody in the district attorney's office, including victim witness advocates? And that she did not answer. That's it. That's the sum total of the argument. She explained that she did not realize that that question pertained to her, and she explained to the court's satisfaction. As Justice McMillan had mentioned, that's
So
something
they didn't
that
probe
the court
later when they found
no
out more.
misconduct in its ruling on the motion for new trial.
Although, I mean, that strikes me as exceptionally implausible that anyone could actually understand that question, which was a fairly straightforward question, as not
Exceptionally
asking, do you know
implausible.
anybody in the DA's office, which is probably why the prosecutor, to her credit, came into the court and said, hey, you need to know this, we should excuse the juror.
Correct. She appropriately brought that to the court's attention, but because
So the
you
state
have
was fine with the
individuals who
excusal and
experience
judge said
things
no?
orally, they didn't represent it correctly. As has already been discussed by this bench, the question was, do you know anybody? And as Justice Bethel indicated, there are a lot of people who hear that question, and that's not what they answer.
Bro, come on.
I will point out, everyone ahead of this bar right now are individuals who read lots of transcripts. And I submit to this bench that the question that is most frequently misunderstood by witnesses on the stand is, do you know somebody? You'll ask, do you know John Smith? And they'll say no. Isn't it true that you went to high school with John Smith? Oh, yeah, but I don't know him like that. That is the most commonly misunderstood question that you have. And that was the question that was put to the jurors, was, do you know
Yeah, we're not talking about high
And of
school,
course,
though. We're
there
talking
are
about
some
something
people who try to
concurrent.
overrepresent what knowing means as well.
Correct.
You know, well, I read about them in the paper, and so, I mean, I do see that ambiguity, but you would agree that this was not an ideal situation.
No, which is why the prosecutor sought to have it determined by the court and to bring it to the court's attention. I will point out that I don't think the record is 100% clear on how this information came to be, because you have the juror saying, I told this information to Ms. Simpson, your assistant, when I realized later on that maybe it did apply to me. And so it's not quite clear either way, but either way, this person, as Your Honor mentioned earlier before, with their demeanor and their character being presented to the court in live testimony, gave the explanation, I didn't realize that question applied to me. Jurors, like everybody else, have the capacity to be wrong.
Counsel, let me ask you a question.
I don't.
Do we have a problem because the court only asks, does this have any impact on you, versus asking, can you be fair and impartial in light of your working relationship or whatever you want to call it with the DA's office? Was that question that the court asked sufficient?
I believe so, especially considering that in the first colloquy that the court had already asked about fair and impartiality. And so this is
Not a
something
good
that an
argument when
ordinary
you start
person
off by
going with
saying
what people
the question
understand,
everybody asks is
things that
vague
are being asked to somebody go.
about
an
what
ordinary
knowing
person would
means.
understand that when you're being directed to fairly judge a case, does this have any impact on you? That's asking the same question by different means. And so this is not a case.
I mean, you would agree that, and you already have, it's a pretty valuable component to lose the opportunity to use one of your preemptory strikes on someone who has an active case in the DA's office.
In the
Correct.
same courthouse.
I will say that I will go again with the fact that this court has already addressed that issue in Green and put to the superior courts the determination of whether is this person truthfully mistaken or is this person untruthfully mistaken.
So on the point you mentioned about it's not clear, I tend to agree. I mean, it seems almost like maybe someone in the judge's chambers was notified, hey, there's an issue, and that may have triggered the district attorney to go look.
Correct.
Curiosity question, does, in a large prosecutor's office, do y'all not scrub the veneer panel against your active files for witnesses and victims?
Do you check if someone has active
To
counsel?
do that based on how Fulton County's case management records work as far as victims or witnesses. I just
You
don't
get a
think that-
veneer
No,
panel
you
from the
don't.
clerk's office,
Correct.
and you have your own records. I'm not talking about I don't know about Fulton County's case management. The DA has its own, clearly would have to have its own database of witnesses and victims.
You can do a name
So-
search, can't you?
We have a case management program, and I've been using it for a decade. I can honestly tell you that I don't know how I would particularly look for a witness. I imagine that there's circumstances in which that could occur. I will point out that it is required by law for somebody
Not
to
a witness, though, it's the
contact
victim. It's the
somebody
victim
to
of
let
the
them know
crime.
when hearings
Not
exist.
just a
And
witness.
so being in regular
So there's a
contact with
list
somebody.
somewhere that people are contacting.
Correct, for those separate cases, but
Mr.
it's not
Armstrong,
something.
when do you get your jury list?
We get our jury lists when the jurors walk into court. It is a sheet that includes their names and their juror ID numbers and I believe their addresses. And it's
Generally,
something,
on a felony case, how many jurors are you calling for on a given morning when you're starting a homicide case?
for a regular homicide case, there will be 60 jurors in the courtroom and there will be several hundred in the jury room, which I can't remember what the name is.
Assembly room?
Assembly room, that's the word, yes. And so this is not something that the court would not have been authorized to make its own determination about whether there was a concern with this juror's truthfulness when they were responding to the court. And so I submit to this court that this is not a basis upon which this court should or could grant a motion for new trial, especially given the court's finding that there was no misconduct. And if there are no further questions, I yield the remainder of my time.
Oh, I should add, Quay, the
Thank you,
defendant
Mr.
here,
Armstrong.
had to wait for
Mr.
over a
Steele,
year
well
for
argued on
his
both sides. We'll get
motion
y'all a
for new trial
decision in the
transcript.
time required by the Constitution. And with that,
A very helpful transcript
we
here,
will
too,
adjourn
that was relied
until
on.
the January 2026 session of court.
All rise.
What was that January date, Hal? The
20th.
20th?
Yep.
Okay.
Yeah, it would be Noah Pines, Brian Steele, and I think a third-year law student. There's a third one's a habeas case. I wasn't able to find any info on it. It was Fred Head, for those of you familiar with one of my previous streams, who is the warden in something. I can't remember where. Butts County, one of the Butts County prisons.
Oh, well, that was very cinematic how they ended this.
It was.
There's no escape button. All the controls went away. And I know we talked over the beginning of this because I didn't realize there was no rewind controls. But if anybody wanted to go back and play that, usually you can do so after it processes.
That was pretty
So,
niche.
yeah, after that processes, if you guys want to catch the beginning of the Jackson and Stevenson case, it should be playable over on the Georgia Supreme Court website under oral arguments and the webcast tab.
That case was so stupid. If you value your brain cells, don't do that. I should say, like in arbitration, it's usually like it's kind of a two-step process. Like once you're in, but you have to clearly like opt into arbitration. You can't just like accidentally end up in arbitration. Like you're very strictly tied to the arbitration agreement, but like you have to actually agree. So it's like a very strict standard both ways. You're strictly bound to it, but you have to like actually be a part
I
of the
wonder if
agreement.
there was confusion because it seems like Jackson was the owner of Rickshaw LLC, the only person, and in real estate, it's not uncommon for investors with their portfolio of property to put individual properties in individual LLCs, and that LLC will only exist to hold that single property as an asset. So maybe because he was in court already, maybe there was like some type of discussion like, well, you're also here to represent Rickshaw. And it was kind of like, but they didn't really get into that type of question. I don't know if if the justices thought about that. But to me, either way, it kind of seems like the issue was Rickshaw, whoever was representing Rickshaw as a party for Rickshaw, not just I happen to also be the owner of Rickshaw and I'm here as myself. Was Rickshaw compelled to arbitrate? And I think that the justices are leaning, if they were compelled, then it doesn't matter if they were advocating thereafter.
Oh yeah, for sure.
So
yeah, I don't think it's even like I agree with that. I don't think it's that close though, because there's very like it's very hard to like stop your way into arbitration. But yeah, I agree with that.
Yeah, I'm pretty boring. But and then I think with the case that we just saw with Brian Steele, you guys, I pulled up the brief while that was going, and there were other arguments raised, so like sufficiency of the evidence and ineffective assistance of counsel. But I do think a strong point on that juror issue is and it seems like from what we heard orally that the prosecutor had no problem with the juror being excused, juror 70, whatever. And the defense requested it after learning the information. So they didn't learn the information until trial was already underway.
Yeah.
And we heard Kevin Armstrong underscored, intentionally or not, that the judge didn't ask very many probing questions when it was brought to his attention that, hey, there could have been a dishonest response from this juror. They just said, okay, and then kept it moving.
I like Newkirk too, but he definitely.
I think it's kind of an issue. Why not just excuse the juror? And either, I don't know if Steele was arguing in his brief, because there was a motion for a new trial on the issue.
Yeah.
Was there a request for relief to just excuse the juror? It seems like the judge denied that, and I don't see why a judge within their discretion would not just excuse the juror.
Yeah. Yeah, for sure. Yeah, I thought he was going to focus on the second issue, the search warrant issue.
The failure to request suppression of evidence?
Yeah.
So, guys, that would have been an ineffective assistance argument for the trial counsel failing to move to suppress evidence that may have been the result of a unlawful search. If you know that issue and you want to run down it.
I don't know it super well. Like I said, I actually was in touch with the defendant, Quay. He knows, like, he's friends with, like, Darren Mills and Quatez White and, like, Lucci and all those guys. It's like from the same area, same time frame. But yes, so there was a search warrant for the car. I guess there was some kind of drive-by, like an actual drive-by, not like a Moonton drive-by where they just make it up, but like an actual drive-by. And in theory, anyway, that was the theory of the case. And so the police got a search warrant for like the two front seats of the car, or I don't know, the passenger and the driver, like front seats to do gunshot residue testing. And apparently they just searched the back seat, and the police found what they call a single particle of gunshot residue, which I have a million questions about. But the
just
issue
one particle.
That's not really how that works. Like,
well, and also, if you can find just one particle, that makes me think of Shart questioning during the YSL trial. You looked on the headboard and the seats and the whatever covers the ceiling, and you didn't find that one particle, and they're like, no. So then the state would argue, well, you can't, just because we didn't find one particle, it should be fine. So it seems like the reverse argument.
Yeah. But yeah, it was going to be suppression because they searched the back of the car, the back seat of the car, when the warrant was explicitly limited to the front seat. And also, like, there's no, like, a GSR particle. It's not like they find a particle and, like, you look at it under a microscope and it's like, oh, it says gunshot on this particle, so we know it's gunshot residue. Like, it's just certain elements, certain like chemical compounds that come out. If you find a single particle of gunshot residue, like, I have serious doubts about whether that's even what that is, because there are other things that produce.
Well, and couldn't it just be like a touch DNA type situation where it could be like the little piece of particle that could, and it just like transfers yonder?
Yeah. Well, that's what they were saying in the YSL, right? Like, you can hold your arm out of the window and shoot it, and then it'll just like drift into the window. So there's not like a gun. Like, if you're just near the car, if you're near a gunshot in your car, like a single particle could get into the car.
Oh, so I just caught this at a glance for the ineffective argument, right? Because it's not just a random argument about failure to suppress. It's specifically ineffective assistance of counsel because trial counsel didn't move. And you have to dispute that, that decision wasn't a conscious strategy choice that a reasonable lawyer could make. And here they're including in the brief that, moreover, appellant's trial counsel, so Malcolm's trial counsel, testified that he knew that the gunshot residue found in the car was extremely harmful evidence against appellant. So there's no reasonable strategy you can try to come up with to suggest, hey, there's a reason that we're not moving to suppress this.
Yeah. Yeah, he fell on a sword completely. He said that he knew that it was an issue and that he knew he could have done it, but he just didn't. Which is, the right thing to do. Yeah,
there you go. The scope of the warrant. All that stuff. So, guys, And as Hal always points out on his, whenever he does Supreme Court arguments, if you jump over to oral arguments on their website and you go to case announcements, they don't have the January ones up, but they usually do this like, I don't know, like 3-4 weeks in advance. You could see December 9th was today's arguments, and it'll pop up this document and it gives you a summary of the issues. That way, if you don't want to read the briefs, you can still get the, and remember, just because arguments, things happened at trial, by the time you get to the Georgia Supreme Court, you might be honing in on a specific issue or 1 or 2 issues.
Yeah,
so,
for sure.
and that's for a case like the Fani Willis case and the Equitable Estoppel case. We're taking this up because we want to weigh and make some type of analysis and come up with a resolution here. When you get to something more like Malcom v. State, that's different. Like, this can be heard because it's a, murder conviction.
Yep.
Life sentence, and thus the lower courts of appeals don't have the same jurisdiction.
Yep. Yeah, it goes straight to the Supreme Court. Exactly.
Yep. So that's why you'll have this mix of like a civil issue, and then this jumping right up to the Georgia Supreme Court. But and in any case, there's links. They put the links to all of the briefs. Oh, I didn't switch my screen over, but it looks like this.
Yeah.
Case summary, and then links to the brief for each case. So if you ever want to deep dive, and again, I recommend it because we only heard Steele argue the one issue, but there were additional raised in the brief. And that doesn't mean the Supreme Court justices are not going to consider the other issues raised just because they weren't argued orally. It's just, we're using those 15-minute slots, which never seem to be limited at 15 minutes.
Ooh, there's a bunch of opinions that were dumped today too, actually. I didn't notice that. I just noticed that now. Oh, can you show them actually? Can you go back to the Supreme Court one and show, I don't know if you know how to do it. It's
under opinion.
Yeah. So
wait, is under forthcoming? Okay. Oh wow.
Yeah, if you click summary of noteworthy, they'll give you the basically the same thing. Oh no, it's the yeah. It's basically like the same thing as before, but they just give you the results. Vacated a
somebody won.
Interesting. McMillan.
So these are all going to be civil when it's 2 names.
Vacated.
Let's look
I'm guessing they affirmed all of those. Any interesting counties? Let's see. Do I know any of these names?
Bibb, Henry, Fulton, Coweta, Cobb, DeKalb, Carroll, Hall, Walton, Liberty, and Chatham.
Yeah, so those will all be murder cases. They're just direct appeals.
Yep,
but
all upheld.
Sometimes I like to look at the very bottom because they have like the lawyer discipline. Sometimes there's some juicy stuff down there.
Voluntary surrender of law license from Janita Lane. You just go here for the tea to see who's getting yelled at.
Oh, of course. Like that one, the one with the magistrate judge that was calling the local news in an accent to talk trash about the chief of police. You remember that one? You found that one.
No, maybe. No, I don't think I remember.
Yeah, it was the judge. He was like calling in to the local news and he was using like a French accent to like talk trash. And then he like showed up at his...
That's the thing from like a decade and a half ago, right? And it's still on like YouTube?
Maybe. Don't judge me. Yeah, and then he was like talking. He showed up to his sister's boyfriend's house and like kicked in the door.
Yeah, yep, I remember that. Okay.
Yeah. My kind of judge.
Guys, if you want to hear about messy attorneys, you guys have heard me say a few streams ago I had to get caught up with what's going on with the HTC and the Lauren Matthias.
What
I don't even know how to say her
name. Mean? I haven't seen that lately and I'm too afraid to ask.
Something true crime.
Oh God.
Something hoopla true crime. Any H for whatever you want it to mean. But her attorney, Dolly and Hella, have been doing a ton of research. And Dolly Talk yesterday with Hella as a co-host went through what Lauren, whenever there's like a messy plaintiff, there's usually a messy attorney behind them. And Hella was like, I suspect that like the attorney is like, she's taking inspiration from the attorney. Well, Dolly pulled up all these documents where the attorney is like abusing family court, fraudulently changed his children's names, but signed his wife's signature and had the documents notarized. But he's an attorney. And this is all this drama surrounding HTC Lauren. This is her attorney. I'm going to link to that stream. I could not turn away from it when I started watching it yesterday. But if you guys like to hear about messy lawyers and watch that saga proceed, this is a replay to watch. And it won't go to Hal's chat from here, but just search Dali Talk, D-A-L-I, like Salvador Dali.
Man, like sometimes I like worry about like whether I'm gonna get in trouble for like the way I like time my pro hoc admission, or like am I gonna get in trouble for practicing with a license because I talked to somebody about whether I'll eventually be their lawyer in Georgia and I'm not admitted there. And then I like look at the discipline and it's like this lawyer stabbed somebody, then burned their house down, lied to the court about it, and then like we're gonna suspend their license for 48 hours. I'm like, why do I even bother being ethical? Like, why? I should just do whatever I want.
Oh, that's even, you're right. Vague and ambiguous says the notary was himself with the last name that he had changed.
That's kind of funny. First of all, notaries are dumb. We need to just get rid of notaries. Like, what are we doing here?
Oh my gosh.
I have to like, if you want to do a habeas, I think you need to get something notarized. And it's like, dude's in prison. I'm in California. Like, I already wrote everything. Just call him. It's the 21st century. Why do we need somebody that nobody knows to like watch him sign something and then write their name with a little stamp? Notary. They'll probably say that when they stamp stuff, I assume. Just let me file it. He has to show up in court anyway. You're gonna find out if I'm lying. What do we need the notary for? I'm sorry.
True.
I'm vehemently anti-notary.
Please do a stream on notaries. I do want to give guys, when we do simulcast, it's a bit more difficult to like stop, pause, and I think I could just give you access. That way you can also control things on the screen, but I try not to like do too much. But I want to make sure we shout out everybody that has shown additional love. So Guy Vermectin, thanks for being a member, saying good morning to Jim and Kat. And then over on Hal's channel, we have Tanya Garrett with the $20 super sticker. And unfortunately, I cannot see what the sticker is. Hal can see what the sticker is over on his side.
Ooh,
but
yeah,
I wanted to make sure we say thank you to Tanya, because StreamYard just shows me the word super sticker.
Oh, not your channel. I should go to my channel.
Hal is lost.
My bad.
Derek, thank you also for the super sticker. We had Amber Donham Johnson's become a member, which, how are you always re-becoming a member?
Dude, I have 60 viewers. That's pretty good.
Heck yeah, make sure I'm going to drop Hal's link one more time for my chat if you want to make sure you also subscribe to his channel if you're not already. I'm also going to redirect my stream over to Dolly Talk, who's doing a courtroom roulette. So get to watch more judges, hop around. A lot of it's like arraignments, pleas, just quick moving stuff. That's why it's called a roulette, but it's really entertaining to watch.
Wait, how do you redirect stuff? I don't even know how to do that.
Oh, I'll teach you right now. Okay, so
okay,
click your profile picture and go to YouTube Studio on YouTube.
Okay.
And guys, if you ever want to like tell a creator how to redirect, this is how you do it. Then you go to your content, and then you go to your live tab and find the live that's currently running.
Okay.
And then edit. And then there's a tab,
okay.
there's a sidebar on the left that says details and customization. You want to click customization?
Details. This is so many steps. Okay. Redirect.
And then, yep. And then you just go, you can choose, there's like 2 sections. You can choose like a video of your own. It only show you your own videos that are scheduled.
Ooh.
And then like if you would do like a series and you want people to go to the next thing, you can do it that way. Or other channels. And then it'll show you any of your current subscriptions that are currently live or have a scheduled live. Otherwise you got to search, or it'll show you like random things that are live.
Ooh, I see. Oh, Nick's live.
Cool. So Hal's going to redirect to Nick. I'm going to redirect to Dolly. Dolly or Nick will probably redirect to each other at some point.
Sure.
So we'll just do this whole big travel all day. Also, guys, if you've been following Mickey Steins, Taybiz TV is going to be live today talking about the Mickey Steins updates. So that's the sheriff shooting judge case. So we're going to close. Do you have any closing thoughts? Because I'm going to throw on some ABCs of Steel.
No, nothing. I might stream later. I don't know. I get some stuff. Okay. So there's this thing in Georgia, and these appellate lawyers they're just lying about everything now. It's like every time I look into a case, like you're supposed to resolve the facts like in the light most favorable to the prosecution. They're just like resolving them in like the light most favorable to whatever they want them to be. And I don't want to complain about that. So I might do a live later. I also might do actual like work, but we'll see. But yeah, that was a good stream. That was fun.
And I'm assuming you'll be live on the 20th for oral arguments.
Yeah, probably.
Okay. Sounds good. I'll be there to hang out and watch.
Ooh, let's check real quick to see if there is a Moonton decision yet. I know there isn't, but I'm going to check just in case. Let's see. Not California Court of Appeal.
There's another Moonton in California.
That'd be kind of funny, actually.
That would be funny.
There's nope, nothing happened. I knew that, but I'd still check multiple times a day.
Yeah, and I'll do some docket updates and see what's going on. I think the next thing for me, I'm going to be diving into the Zachary Adams fight for a new trial post-conviction up until we're supposed to have a Courtney Clenny third bond hearing on the 18th. I'll also look for an update on the 17th, guys. I want a status update too from Fani Willis to see if she appears to testify on the 17th.
Oh yeah.
So those are the next two dates I think I've got.
What's
but
the deal with
everything in
Zachary
between.
Adams?
Zachary Adams is a rabbit hole, you guys. I think Zachary Adams, the prosecution, has less integrity than what we see from Fulton County. It's the most insane thing that I've watched, and partly that might be because, with appeals, you read a lot on paper, maybe you get to hear some oral arguments, but you don't really get to see how the sausage is made. Well, what Zachary Adams' current counsel, attorney Doug Bates, is doing is actually a quorum nobis, which means he's taking this petition for post-conviction relief to the same trial court where the error is occurred. And in Latin, it's something short of letting the trial court have a chance to correct its own mistakes. And the issues that they're raising, there's new evidence. The prosecution not only hid an ATM surveillance video that alibis the 4 co-defendants, but once the defense kept looking for it, and Doug Bates keeps looking for it and tries to get a subpoena out there to go get the video, the prosecution team, this was in 2024, or actually might have been earlier this year, opens up an investigative case number for the sake of taking out their own subpoena to go and get the DVD drive from the bank where the ATM surveillance footage is being held before the defense can go get it, after the court issued a judicial subpoena for the defense to finally be able to get it. There is no way to reconcile how something that the trial counsel was requesting access to back in 2016 and 2017, that suddenly when the judge says, here, defense, you now have this judicial subpoena, which gives you the opportunity to go get this thing finally, that they have a prosecutor, Kathy Ferguson, drive hours to go get it the very next day, to go get the physical device so the defense cannot get it.
That's not even being good at corruption, which is what really offends me.
And it's so much worse. There's so many other errors. They have a probation condition. So one of the co-defendants is Dylan Adams, brother of Zachary Adams. He has some cognitive issues. His family members say he has trouble telling time. Well, they rope him up on a federal gun charge, try to get him to talk while he's in custody there. He doesn't talk. They offer him a deal, but one of his probation conditions is to go live with a retired Memphis police officer who's working as a private investigator for the victim's family. And he has to live there. He lives there for 5 weeks, and suddenly he's doing this interrogation, giving statements that are giving details they never had before. But
that sounds familiar.
And they don't call him to testify at Zachary Adams' trial. They don't play this interrogation video, but we've gotten to see it through the post-conviction hearings. And it's just 2 detectives saying things like, and you found the pink panties, and you took her to a green couch, and he's just going, trial jury never got to see any of that. I could go on for 2 hours, so I'm going to stop there. But we've been deep diving that whole case on this channel. We rewatched the entire 2017 trial. The next set of hearings is December 29th and 30th. It's an incredible hot mess.
Is it
An
like
incredible hot mess.
more new trial hearings, or is it
Yeah, so there's been this
still going?
for this
Gonna
for
be
this
longer than the
petition,
trial?
and there's been more evidence presented than was presented at the trial. So, and star witness, by the way, they couldn't put Dylan, so they offered a plea deal to a different co-defendant, and he slips up on the stand and says rehearse. And how long is the clip? Maybe I can just play the clip. We're gonna watch a clip.
Man,
This is the star witness who has since recanted his entire testimony. The Zachary. Sorry, it's me talking
you had
first.
that quick. That was impressive.
Because I had my YouTube open. We're just going to listen to me. If you're wondering why there's all this buzz about the Zachary Adams trial and his fight for post-conviction relief and a new trial, there's a lot of reasons. But here's a big one. On the screen is the star witness at trial, Jason Autry, co-defendant who took a plea after a different co-defendant's testimony, statements, interrogation video wasn't what the state wanted to use at trial. So they pivoted and looked to Jason Autry for key testimony against defendant Zachary Adams. Here's a good clip.
So did Mr. Adams say it that way? Did he say, Natalie Bobo left me with the impression that the victim would
I testified that I didn't know exactly word for word, but what I could remember of the conversation. As I told you before, I couldn't rehearse word for word.
Rehearse. Rehearse is a very interesting word. Meanwhile, fast forward 3 years later to his plea hearing, Jason Autry's plea hearing, this same witness that we're looking at on the screen right now. This is what the trial judge had to say about the credibility of this testimony.
To account the importance of his cooperation and his credible, truthful testimony at trial.
I addressed earlier at the motion for new trial on the co-defendant. His testimony was some of the most credible, persuasive testimony I've ever heard given in a courtroom.
And it answered many questions that were left open factually in the investigation. It answered many questions that Karen and Dana had about what happened to their daughter. And it was a very important piece in getting justice for Holly.
Yeah, that's special.
So big indicator there that without a star witness rehearsing and getting what he was doing was going through his discovery folder and picking out details from different people's reports. One that stands out to me, some guy named Brian Vitt says he was mowing the lawn that morning. And Jason Autry gets on the stand and goes, and Zach told me he saw Brian Vitt mowing his lawn that morning. And he does that with detail and sprinkles all these little details in from his discovery folder.
Yeah, sprinkle. True.
But there's that, guys. It's a whole hot mess. This judge is retired. So I think the reason Zachary Adams has any chance at all, I think the issues are astonishingly significant. But I don't think this judge would have given them a chance at all.
Yeah.
So, but yeah. Other than that, you guys, I totally recommend checking out that trial. I'm all the way in. All the way in. Yes. The judge, as soon as the state started their closing arguments, the judge stands up and walks down to the witness booth to grab a tissue.
Yeah.
So.
The victim's mom passed out on this. What?
Yeah, the victim's mom passed out on the stand. But to be fair, I don't know why the prosecutor, I think they did it on purpose.
Yeah.
You know, you might have a mom say, hey, that morning I saw my daughter wearing these belongings. That way, like a TBI, an investigator can come in later and say, well, we found those belongings. They were identified as being Holly's, as the mom, we're connecting it to what the mom told us. But the prosecution was having the mom unbag all of the evidence, which, even though they had someone else come on to talk about the same exhibits later, but to me, that's very, one tool for dealing with grief. They say, like, put a loved one's belonging in a Ziploc. That way you can, like, have the smell to remember somebody by, because of the way our senses are so strong. And here you have this prosecutor, like, I think it was strategic to evoke a physical reaction that Karen Bobo, the mom, could not control on the stand.
Yeah, yeah, they definitely did.
And she was the first witness called.
Yeah, there's a DA dispatch about this specific topic, actually, about how you're not. It's one thing to like call a family member because you have to like identify the deceased, right? You're like, it's just a technical thing you have to do. And usually it's like you show a picture of the decedent and then you say, oh, that's this person.
Yeah.
And you usually like, it's better
Have
if you
somebody
can
else
call-
do it.
Yeah. I mean, obviously they have to be like somewhat close to the person, but you don't get like the mom to do it because, you know, they're human. They're going to be upset. They're going to like, it's like what they're doing on the stand is going to extend beyond just identification. They're going to be upset, which is reasonable, but it's not really, you know, conducive to a fair trial.
And I'd say, guys, we always wanted to see Love get made a witness, put her on the stand. With these post-conviction proceedings, we got to have two prosecutors on the stand for several hours. So if you like watching hot messes where prosecutors have to testify, that case has it all. It's also got horrible, like, ballistics. And I'll just link to this video that the Trial and Error podcast did. During trial, the jury, the state just ignores that there is a 380 auto casing found next to Holly Bobo's skull. And there's a 0.36 inch diameter defect injury to Holly's skull. But nobody ever explains to the jury that even though it's called a 380, what's ejected from the casing when something's fired is actually only 0.355 inches and could have caused a 0.36 inch diameter wound. Prosecution in closing arguments says that the 380 auto was excluded. In closing arguments, they argue this, that it couldn't have been the 380 casing that was found right next to Holly Bobo's skull because it's too big.
Oh, so the casing's 380, but the shell's 355.
Yep. And
Okay.
trial counsel, that's an ineffective assistance of counsel argument. And also, like, a prosecutor shouldn't have said that in closing argument. It's like a twofold enumeration of error. But just a crazy... Again, I could be here for like 24 hours. I could do a 24-hour stream on this case, and I might. So,
You're gonna end up like the meme from Always Sunny.
just have you
Hour
seen
22.
it? Have you seen what I did to change my new picture for that trial? I already have it locked and loaded. So I just changed my picture when I take a break to the Charlie meme. So, yeah, and Jeremy Rose says a 4-year-old could have done better. Yeah, I should think of doing something like 24, and maybe I can get Dr. Katie Spurko, who was working as a consultant on the case, and then the prosecution moved to sequester her, made her a witness so she couldn't talk about the case.
Oh man, that reminds. I have a chance that I could get Jackie Johnson on the stand, and I would love to have that happen. There's like a very real chance that's going to happen, like within the next year.
We would watch.
Because she's a liar.
Dropping this again, it's the Trial and Error podcast. They have watch all of their episodes. You'll understand the issues with the case. I've gone through all the post-conviction hearings. It's insane testimony. You're going to see great lawyering from attorney Doug Bates. We now have an emoji for him in the channel emojis. He's so great.
I know. He's like what I pictured GSU grinding to be. I've never actually seen him argue, but like in my head, that's who he is. I told him that. I don't think he was very amused, but you know, I'm not a big city lawyer like you.
I don't think I have a ready to go picture of Doug Bates. I just have I don't got one. But there's an emoji. There's a channel emoji for him. But there's been good times.
Cups? I have 2 cups this morning. I have my big gulp coffee because I'm classy.
This was the trial prosecutor mid-testimony at the post-conviction hearings. I'm telling you, it's like she was waiting, she was praying for the ceiling to fall down in on her and make it stop.
It's like Beth Harmon situation or something. She's like calculating on the ceiling.
Oh, man. Yeah, and Mr. Big Play Bray says, please get Jackie Johnson on the stand.
I'm working on it. It's like everybody in that case. The case I'm talking about, like the line prosecutor, the district attorney, the judge, the habeas judge, the appellate attorney have all been implicated in unethical conduct or convicted or criminally charged. Do I have an emoji of my favorite judge? Remember that picture, the AI picture I made with him standing in front of the courtroom hiding the bushes?
Yes, that was a great one.
That was good.
Oh, I've also, if you want to get into the Zachary Adams trial, I had to put Kathy Ferguson, investigator, into the bushes. I think she takes the cake from Viverito. There's 4.5 hours of her on the stand, so
Viverito.
Definitely worth a watch. I think that wraps it up, though, you guys. So come hang out if you want to watch a hot trial mess. We're going to be looking at more of the post-conviction stuff and weird. I didn't even get into how they ignored the serial rapist down the street, Terry Britt, and his van, where there was a hair found in a rope in the back of his van that could have been Holly's. Yeah, a serial rapist.
In a van?
It's so much, you guys. It's so much, you guys. In fact, I think Trial and Error has the vans in a thumbnail. I could just show you real quick. Episode 4, the Terry Britt episode.
My goodness.
Oh my god, where is it? Is it here? Maybe it's like in the middle of... Oh, there you go. So right on the screen right there. 2 of Terry Britt's vans. Over here. And he's on, like, they wiretap his home, and he mentions on the wiretap that they're not going to find anything in the red van. But then they end up finding, like, a hair and a rope in the other van.
There's a rope now?
But the prosecution argues that the wiretap cleared him, even though he knew he was being wiretapped and could have been self-censoring.
We should do a stream where you just explain the case to me. That would be fun.
I'm going to have... So Dana McClendon is trying a case right now. That's him on the right. But when he's done, he said, you should ask me to have a couple drinks and explain the cell phone mapping in this case. So I'm thinking like the Charlie meme, but it's going to be Mr. McClendon here. And I will certainly announce that ahead of time so you guys can all hang out. That'll be a great, even if you haven't tuned into this case yet, having him explain how the cell phone evidence that the jury couldn't have properly explained to them by an expert at trial shows that Zach Adams was at an ATM at like 11:12 in the morning. And then his brother, who he's also in the vehicle with, they remember driving backwards. They back their pickup truck backwards through the ATM because Shane Austin, who's now killed himself because he was facing the death penalty and he was maintaining his innocence. He was in like the passenger side of the truck. So Zach's driving and he backs into the ATM. And he tells Katie Spirko this detail before anyone has ever seen this ATM surveillance footage. This is before the subpoena gate happens. That's a pretty specific detail to remember from 2011.
Yeah.
And he remembers that. And at one of the hearings in January of this year, Zach is sitting in court and tugs at his attorney Doug's sleeve and says, "That's my truck," and points over to Prosecutor Boyano's screen that has a Chevy Silverado in an ATM on his tablet screen in the middle of court. That's what started the subpoena gate. Because before that, they'd been denying the existence of this video. They said, you have everything that we have. They changed the file name of it to just say BP rather than, it used to have the terms ATM and surveillance. Was it Simone Hilton?
Yeah, that's her move.
Shout out to some guy with cancer. With the super saying the entire Zachary Adams case is making a square peg fit in a round hole. Yeah.
I was like, what's some guy with cancer? I didn't realize it was his username.
I know. I get joy saying it with like such exuberance. You got to keep it positive. But yeah, that's why I see the Simone Hilton reference. I would say this is worse than the Wolfenbarger trial, you guys. So if you tuned into that, this is even worse.
Yeah. That case was like, it was just dumb. This case seems like the Zachary Adams case, like there's actually a conviction. The Wolfenbarger case was just like, what are you doing?
Yeah.
Just stop. But McDermott, from what I've heard, the jurors had decided by day 2 to acquit in that case. That's the word making its way through the grapevine, which would be the day the detective was like, no.
Because the detective that pointed at the prosecution team about the VHS was like one of the first up. So
yep.
We were watching the trial for like 5 minutes and we were already like, what? Oh man. They never do any better.
I was mad at Law and Crime too. Their coverage of that was ridiculous. But
well, that's why it's good to check out different, and I like to shout out and support people, but part of the reason I shout and support so many people like, I like to hang out in different chats too, especially there's things that I watch twice, 3 times. Just to hear the material again, like rewatching testimony can be helpful, but also seeing what others point out, what other chats point out. So I'm a huge advocate for, I love Law and Crime. I love all that they do, but sometimes it's just good to go to a different bubble once in a while.
Yeah.
Don't stick to one. So.
Yeah, that's my project is on the Wolfenbarger case. If I ever finish it, was the way like Sheriff McCollum, who is active law enforcement in Hapeville Police Department, and is a member of the Fulton County cold case team, is also doing a podcast like explaining why people are guilty on the side, and like leaking evidence and polluting juries.
Yeah, and if it was the other way around, I think it would be similar. Like here, the prosecution was quick to make sure Spirko can't talk about this case.
Yeah.
So, and she should be able to, again, once these post-conviction hearings are done. That's going to be fire. But all it's done is, in the meantime, she decided, well, I'm going to work on season 2 of this podcast, and we're going to look at more victims who don't get justice because nobody's looking at their case correctly. So there isn't really justice because we're just trying to get an easy win, whether it's the right person or not.
Yeah.
So.
Like I'm all for like doing cold cases, but they didn't even like do a cold case. They just charged an old case without actually like investigating anything. It was bizarre. There's like the media, all the media, even on Twitter, even like people on Twitter were like, there's a break in the Wolfenbarger case. There's a break in the case. And nobody ever like said what the new evidence was. And there wasn't any new evidence.
There was just some girl saying that he looked creepy at a party once, and that girl she was an unavailable witness. She was an unavailable witness anyway.
Yeah, and the detective said it wasn't credible.
See, I'd be forgetting all the different layers. Because in that one, we forgot we have the serial killer parents, and then that couldn't have done it because they get on the stand themselves and say Carl Patton would never kill his own family members.
That was one of the dumbest things I've ever seen in any context. The serial killer would never kill anybody. That's what they said. That was the angle they took. That sounds like a joke, but that's what they said.
This was Simone Hilton, Vincent Fawcett, and I forget the other guy. And there was a successful motion for directed verdict in that case. You guys know we always enjoy, like, oh my gosh, an actual shot for a directed verdict being granted, because the state in the indictment, they couldn't match the evidence they presented at trial with the theory that they indicted for felony murder, the underlying assault with a specific type of weapon. They had no sufficiency of evidence on the record by the time they rested their case to show that a particular weapon was used in the commission of a felony that would have ultimately resulted in the victim, Melissa Wolfenbarger's death. And they tried to argue it. That was some of the most hilarious struggle arguments I've ever watched in my life. And Judge Rachel Krause was like, no.
There's an issue that they didn't even get to because they didn't need it, but there's like a venue issue where, okay, so like if you have to try the case.
You don't know where.
County. Yeah, and you can allege it as like, we don't know where she was killed, but we found her in Fulton County. You can do that, but they specifically alleged that she was killed in Fulton County.
There.
She was last seen in Cobb, I think, or DeKalb. I think it was Cobb. It was either
wherever
Cobb or
the Waffle
County.
House was.
Yeah, that was the last time she was seen. And they said that she wasn't killed where she was found. How are you going to prove venue if you're saying that she was last seen in Cobb and killed somewhere else? And they didn't even get to that. So, like, on a motion for new trial, they absolutely would want, even if there had been a conviction. But it's just like one thing after another.
A good time. A good time.
There was the boyfriend, the Waffle House boyfriend, the roof of the Waffle House lover. Apparently he stabbed somebody that same year.
Yeah, it was like an armed robbery.
Yeah, like he stabbed somebody.
With something that could have been in the category of weapons that they were alleging was used for this crime. Like it's like the same like bladed weapon. I forget what's included. But there's like a difference. Like if you use like an inherently deadly weapon, like a knife and a gun would be defined that way. Versus just like Vincent Fawcett was trying to argue against the motion for directed verdict by saying hands are an inherently deadly weapon. Fists are an inherently deadly weapon. Thus, if there's any evidence on the record that Christopher Wolfenbarger may have choked Melissa, then a reasonable jury could infer that this indictment, as delivered to them, that they can come back with a guilty verdict on it. even though it was defined as using a deadly weapon.
There's just as much evidence that aliens came down and killed her as there was that hands, like the Waffle House boyfriend. I made so many jokes about that at the time. Oh my goodness. My favorite, okay, this is the last.
Yeah, the roof specifically of the Waffle House.
The roof was on fire. The Law and Crime sent a on-scene correspondent to go to the location, to go to Action Glass, where Christopher Wolfenbarger worked, and he went down the street. He went to the wrong place. And you can see it like way off in the background. You can see Action Glass. And he was like confused because the state had misrepresented where certain things had occurred. And he's like, Action Glass is located right behind me. You can see the sign for Action Glass way down the street. Oh, God, I was so mad.
We're going to have to get the aliens guy, too.
Wait.
The guy with the hair. Oh my God. Yes, Hal. And also, what's Malcolm? Because you're saying Quay, but what's his full name? Malcolm? Blank Malcolm?
DeQuavion Malcolm.
Okay. There you go, T. Wood.
I was explaining. So Quatez White he and DeQuavion Malcolm know each other? Yes. And I was explaining this to somebody, and I was like, Quay. And then they're like, oh, Quatez White. I'm like, no, idiot. It's DeQuavion Malcolm. And they're like, no, the name's is QUA. And I'm like, geez. It is Quay, isn't it? There's another Quay that I didn't even notice.
There's so many Quays.
When there's a will, there's a Quay. There's so many Quays.
One more for the road.
Even like there's like multiple other Quays on YSL that I didn't even notice until recently. Like Quantavious Greer, assuming that's his real name. But
that'd be a Qua.
That's true. It's also not his name, but
yeah, or Quinn,
exactly.
Sometimes with 2 R's, sometimes with 1.
Reed's Lexus could have launched into. Oh, yes.
Oh yeah, the old alien theory from the good old Karen Reed physics.
Wasn't like if there's enough force, like her Lexus could have gone into space, which is true. That case was such a mess.
It's the improbable possibility.
I'm so mad. There's so many things that like I didn't even like want to get involved in the Karen Reed thing, but the Karen Reed people found me, like the Julie Carpenters of the world. I was just having a conversation with GSU Grinding. I didn't know who any of these people were, and this Mama Llama person and this Julie Carpenter just start yelling at me. I'm like, I don't know who any of you people are. What? I just said a nice thing about the dude from the case, the old guy, the jacked, sexy old defense lawyer from the Karen Reed case. And I just have these anti-Karen Reed people just yelling at me.
Wait, Alessi?
Yes, of course. And there was an instance where I was doing a stream on like some Fulton County thing. It wasn't YSL. And somebody from the little Karen Reed universe was like yelling at me and making fun of me because I didn't have that many viewers. They're like, when this person doesn't talk about Karen Reed, he doesn't get any viewership. They were mad at me for not grifting on Karen Reed. I was not talking about Karen Reed at all and not getting viewers. I'm like, oh, look at this loser not getting any viewers. Like if I was,
you can't win with them.
I would have been grifting. I mean, I can because I'm me and they're them. But other than that, I definitely can't win with them.
Oh, man. Well, at least you didn't grift by auctioning off a tie for Children's Hospital.
I forgot about that. Oh, man. If
the old stupid grifting Bob Alessi, David Yannetti.
Do you know, like... Okay, first of all, Bob Alessi is probably making $6-7 million a year. The fact that he'd be grifting by selling a tie is one of the dumbest things imaginable.
He needs to make room for more ties.
Probably. Tie me up anytime.
Oh. Well, we're gonna call that a stream, guys. Thank you so much. Anytime I get to co-host with you, Hal, I walk away and my day is just much better because I get a good belly laugh at least once every time we stream together. And I hope you guys feel the same way in the chat. You guys are still talking about his Airbud logic comment.
That was funny. That was a fun moment. That was so stupid. You know what I loved about that is as the day went on, I think we talked about this. As the day went on, Andrew Fleischman found out about it. He's like, "What is this?" And then GSU Grinding found out about it.
Oh yeah, they had delayed understanding of what this prosecution was even trying to argue, what Fulton County was trying to do. At first, they're like, "Well, it seems like there'd be some issues there, but I don't know. I mean, just And then all of a sudden, there were Twitter threads just forming over what Fulton County was arguing in, I don't even remember the case name, but I just know that defense's theory is, there's a vehicular homicide, and the state can't prove that my client was the one driving the vehicle. And they want to bring in a juror as an expert witness because the juror in the first trial where there was a mistrial for hung jury wanted to convict, and he's also an orthopedic surgeon who would probably get on the stand and tell the new jury, while his foot was consistent with braking in a manner that would someone have their foot on the pedal. So, great Fulton County arguments. So, yes, the Airbud logic.
Whatever happened to that case? Isn't that being tried right now?
It should be over. I mean, while we're on YouTube anyway. That was over in Judge McBurney's court. Who, by the way,
his titles too. It's round 2.
Yeah, at first I was like, wait, why is it was there a second part? And then I realized he's calling it version 2.0. I see day 4. Oh, didn't he say he had calendar call Monday and Tuesday this week?
Maybe.
So maybe they didn't. Maybe there was a verdict at the end of this, but I remember them saying during the jury selection planning that they needed a jury that could be at least through Wednesday because they had stuff to do today and tomorrow, or yesterday and today.
That makes sense.
There's that, you guys. 4-day trial and the original trial somewhere further down on his calendar too. I mean, maybe we can get around to figuring out time to commit and watch that, but I'm assuming it'll be over before that. And O'Bailey's Actual Eye. Is that actually launched, the Bob Alessi and David Yannetti podcast?
I don't know, actually.
I know they were launching it. I didn't know it actually launched yet.
I mean, they're kind of old. It's going to take them a little while to figure it out.
They can hire people that'll do it.
Yeah.
You can hire an intern. With that being said, you have your redirect set up. You saved it.
Wait, my what?
You set to redirect to Nick Starro?
Yeah, I do.
Okay.
Yep.
So Hal's chat on YouTube is going to be carried over to Nick Starro. Is he doing the hyperbaric chamber stuff still?
Yes.
Okay, so that's what's going to be over on Nick Starro. Dolly Talk is doing a round robin of different courts. Sometimes Judge McBurney makes an appearance, Judge Simpson, lots of fun, hilarious judges. And we're going to get out of here with a good old little throwback song. See you guys next time. Thanks, everybody.
Everybody.
A as in Elisa, and B, Your Honor, as in Barry. C as in Colette. G as in Goldfetter. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. E for buffering. E for Pepto-Bane. S for sly, my friend, and you, as in what you mean. I as in I don't recall. M as in may I sleep. All the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. G for gavel slams down P. T for tell 'em anything. R for rights we stand. I for infinity. Life's a courtroom dance. Keep your stances strong with ABCs of steel. never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. Steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down.